Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican, please, service level.
Is that correct?
I didn't ask you to interrupt me. Oh, for Trump's sake.
Good morning. Holy cow, it's dark in here. Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. It's light here, dark there. Power went off again this morning, 5:38 a.m. Let's bring this up to about right here. Turn on the lights a little bit. Not that much. That's too bright. Too much light. There we go. All right. That's going to work. And now I'm big again as well, so that's good. Good morning. Happy Tuesday. I had to check the calendar there really quickly. Happy Tuesday. It is a beautiful day in the neighborhood, but I hope y'all wore your fireproof underwear because there's a 100% chance of heat in the courtroom today as we continue with cross-examination of Dr. Russell by Mr. Brennan. All right, good morning. It's still dark. Let's see. Good morning to one and all. Where are we at for that? Camera control. Where's my camera control? How does this look? Is that too dark?
In front of the Walmart.
Out? Maybe ish. You can just see the southern Febreze over my shoulder up here. So that's about perfect. All right, and Deer Park, not a sponsor yet again. Thank you for that. Who said that? You are. I saw that. Welcome to chat. Especially welcome to Fire Girl, handmade by Wendy. First in chat today, Fire Girl. You are the winner, or shall we say, the loser. Yes, you are first in chat. We're going to punish you with internet ownership. You're responsible for everything IP related worldwide until we go live again, which will be about lunchtime, unless something strange happens in court, which it could. Hang on, let me get this adjusted. There it goes. Pixel perfect. All right. Either there's a hair on my mic or there's a spider web, and I'd like to think it's a hair, not a spider web. All right, welcome. Have you noticed the Deer Park bottles seem flimsy? They have two versions. They have like the tough ones, and they've got the flimsy ones. I prefer the tough myself. These are flimsy, though. Generally, you have to get the tough ones at Sam's Club, and they have flip-top lids. All right, welcome. We have to celebrate some birthdays, first and foremost, before anything else happens. Well, I guess second and foremost. Second and 4 second. Oh, what? Oh, that's gonna get me in trouble. Anyway, we're gonna celebrate some birthdays because we have to sing before trial starts because we do have our only fan in the courtroom doing its thing. So we're excited about that. We'll keep an eye on that. Audio's on. We're not going to miss a second of court, but would like to not sing over it. So if you have a birthday today, make sure you've previously to this moment told the mods so we know. So we can sing to you and properly celebrate your birthday before we get this day started. Let's see. Karen Yulaki, I saw this post, and I'm okay with it, and I'm okay with it only because of the breakdown of the overtime. The overtime makes it make sense. It's not like she suddenly is doing the same job and got double her pay. She's working 2 jobs and got double her pay, and I'm okay with that. Megan says, Josh, today's my birthday. So Josh, Megan Rowland, today has a birthday. If there are any others, let me know. Is Josh here this morning? I think Josh is here. Josh might not be here. Oh, this Josh is here. Hang on. Let's see. He's busy prepping things. Megan, Shannon, Samantha, thank you very much for that. Our mods are incredible, by the way. Let me just say this for y'all. Josh is like, I'm on it. Okay, we're good. We're in good hands. We're in good hands for sure. There it is. Megan, Roland, and Shannon celebrating their birthdays today. We're going to sing with them. How that works is everybody stands up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, and warm up with me if you will. La 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 la. There we go. We're good. We're in tune. We're ready. We're going to sing to Megan and Shannon. Happy birthday to you. Happy birthday to you. Happy birthday, Roland and Shannon. Happy birthday to you. Megan, Roland, and Shannon, happy birthday. There are many wonderful days. Today is your special day. And I realize there are a million places you could have been. There are a million people you could have celebrated with, but you chose to be here with us. The privilege, the pleasure, the honor, the joy is ours. Hopefully we can turn some of that joy back to you and make your day a little more specialer. Begin by helping yourself to free pancakes at Denny's, IHOP Village Inn, with Waffle House, McDonald's, Tammy Dunlap's house, Andy's Grill, and Bob Evans. Cracker Barrel maybe as well. Have a happy birthday. Really, we sincerely hope you have just an absolutely wonderful day. And if there's anything you can do to make it a little more special than this, let us know. There's not much we can do, but if there is, we'll try. We'll try. I will let you know that for your birthday, I bought myself a present. So I ordered my e-bike. But I looked at the cost and I'm like, I cannot justify that expensive a bike. And so I downgraded significantly. Let's see if it'll still drag me around. We'll see what happens when it gets here in about a week or so. Happy birthday. Mystic Mama comes in with member for 15 months message saying, happy birthday to you all. Mystic Mama, thanks for using your anniversary message to celebrate someone else's birthday. That is awesome. Happy birthday. I just bought an e-bike. Yeah, I'm super excited. I mean, it's a nice e-bike. This one will require me to pedal more than just ride it like a motorcycle. So it's going to be good. All right. It requires me to exercise somewhat. Honey's mom, celebrating 19th year at your current job. That is awesome, Honey's mom. Congratulations. Very few people do that nowadays. It's time for the drum solo to finish off the birthday song. Everyone grab your air drum stick, sit down to your air drum set, and finish us off in style like this. Beautiful. One of these days I have to actually sit down at a drum set and see if that actually makes the same sounds that I think it does in my head. Happy birthday to one and all who are celebrating. If we missed you, my deepest apologies. Have a happy birthday anyway. Why do I look fuzzy? Because everything reset this morning, and I have not even had a chance to focus my camera like that. Now I should look sharp as a tack. But nothing like it. Thanks for the reminder. Appreciate that. If it wasn't for people like you, I would never focus. I would just be like, looks good to me. So I actually have to, because my eyes are so bad, I have to watch for what they call. It's like a focus peaking. So when you focus perfectly, that part of the screen that's in focus, like a little goatee that I'm growing out again, suddenly it pops up in blue. That's when I know that I'm in focus. Fuzzy Wuzzy was a bear. Yes, now you can see it. Before it just looked like I hadn't washed my face this morning. So, but this morning got a lot done. Went outside. The kids pushed the lawnmower around to the car, found the jumper cables. We jump-started the lawnmower. We have a little... the smallest John Deere riding lawnmower that they ever make, which was my concession when I got this house because it has a fairly good-sized yard. Was that I wanted a riding lawnmower. I've always wanted one, and I got that. My other agreement that we had when we moved here was that I get a kayak. Mrs. R.A. just comes in and says, the kids are outside riding the lawnmower like it's a four-wheeler. I told them that's their job because it's charging the battery while they do that. Okay, so the kids are out riding the lawnmower. The lawn does not need to be mowed because my amazing neighbor mowed it for us, and mowed it for us over the weekend. So they're just out there mowing and having some fun, hopefully charging the battery up. But all right, so I fixed the two flats on the lawnmower, jump-started the battery, got that going, did our regular spray for bugs inside and out in the Airbnb. Inside because the renter had seen a spider and she wants the whole thing sprayed. But when you hold the door open for like 3 hours and you're carrying 6 truckloads of stuff in, a spider's going to come in. That's just what they do. They like the cool air. Anyway, so sprayed inside and out. That's all good. I still need to address another issue over there that she brought up, but we're good landlords, so we'll take care of that. Tony Zamora, Recovery Addict, thank you for the best 7 months ever. Tony, thank you. Probably, Tony, I think you need a special title. Probably one of my biggest supporters, enthusiasm-wise, is Tony. If I ask the slightest question in chat, he goes to work to find answers for me. Oftentimes reaching out between times, ask him if there's anything he can do to help the channel, if there's anything he can do that would, that if I need anything done or something checked up on. He's the man. Tony, thank you very much. Appreciate you, my friend. Congratulations on 7 months. That is awesome. All right, we are ready to go back to court. Mr. Brennan is going to kick off the day, still asking questions of Dr. Russell. And if you remember, he ended sort of on a spicy note, and I think it's going to continue on a spicy note. So he's going to do a little reset and remind the jurors of the points that he made most recently and continue from there. Spiders eat other bugs. They do. We want them all dead, though, not just the bugs that spiders eat. We want the spiders dead and the bugs dead. Let's see. Don C says, morning well, a good day for me. 640 quid on a tax refund. 90 pounds added to me electric meter from my supplier, and a bag of 15 kilograms of dog food turned up that I got refunded for. All in a good day. Wow. Those are the best. Amazon's a good, I imagine it's an Amazon order. I'm just guessing there. But Amazon's good. When something doesn't deliver when it's supposed to, they say, look, we'll take it. We'll take it on the chin, and we'll get you the right stuff. And they'll give you a refund. And it's all good. Please remember, we all have different opinions on this case and ask you to respect the opinions of others. If you can't be respectful or kind, you may get a break by the mods to think about it. Not that we don't want you here. Just ask you to maybe reconsider the approach of the information you're sharing. That would be great. Look at this. Amanda H. comes in membership 25 months. Welcome to the gallery. Another month with the best LawTube. LawTube adjacent, I think. Thanks, mods and RA, for keeping this channel as amazing as it is. Amanda, it's amazing because of the people that are here, and you are one of those people. It wouldn't be the same without you here. Thank you very much. Hello, little. Yeah.
Do I turn it on now?
You can try. But if it doesn't start, we'll have to push back and jump start it again. Okay. Turn it off, bring the key in. And park it, and we'll just hope that the battery's charged. Yeah. I have a package? I have a package that says liquid. I got a huge box, but it's not for me. It's for Mom. It's all the stuff she ordered. Okay. That one's not mine. My packages come later. All right. Just realized that Officer Dever was on patrol at 1:30 a.m. when Higgins went to the Canton Police Department. Wonder if she saw him. She was in the parking lot when the call came in hours later. Maybe. Are your children on summer vacation yet? Yes, they are. Yes, they are. Mountain Dew? No Mountain Dew. I have one more in the fridge left over from our trip to Tennessee and beyond. And I've not drunk it. I'm being good. I'm drinking water. This water has a hole in it. One's defective. The Palm 88 says hello from New Zealand. Welcome. Good to have you here. I have a suspected spam coming in on the burner phone. No, it can't be spam. Let's see who this is.
Call from
Legally Blonde.
Legally Blonde. The burner phone thinks that you're spam. But go ahead. How are you doing today?
Thinks I'm spam. That's pathetic. So I called. Okay, so yesterday I was watching with a friend who did not watch the first trial and hasn't really been, like, she's been kind of following along, but not really. But she watched yesterday, which was a good day to watch to get it from, someone else's perspective. And she was not as put out by Proctor's text messages as the rest of us were. They didn't have quite the same hit yesterday as they did that first time.
They edited them this time. So
I agree.
So that was nicer.
I agree.
Everyone's
But
sitting
I
around
guess
saying,
it was
what's the
so
C word?
bad that
Yeah.
even Brennan wouldn't say it.
It was bad enough. I got demonetized for the second part of the day yesterday. I didn't think it was. I mean, we had like a bomb in there fairly early on, but it was enough to demonetize the stream. It was.
That's wild.
It's like, yeah, but so not so bad. Not so bad. Does she, have the mouth of a sailor? Has she, worked around construction at all? I'm just asking for background so I can understand.
Actually, that's a great question. So both of us were raised by truck drivers, so there is that.
Okay, so if you've listened to a CB for more than about 10 minutes,
right,
it's basically like working on the wharf at that point.
That's true. That's true. But so I run an in-home daycare, and she's my co-lead.
Yeah.
So it's like we do have non-potty mouths. Mm-hmm. And so, but still, she didn't even, her jaw didn't drop or anything, which I thought was really interesting. And she also, whatever her name is.
Dever, you nailed it first try.
Yeah. Thank you. I wouldn't want to get it wrong. She might come after me. So she thinks that Dever made the fence look really bad.
Wow. I wonder if she had seen previous to this, like everything leading up on this trial, if that would change.
Well, she's been in and out, and maybe it would. I don't know, because, I've watched both trials with you and also, with every other person who covers it after your stream ends. But
you're an addict. I understand.
Yes, I am.
Well, that is fascinating.
Rabid addict.
Legally Blonde to get that insight from somebody who basically doesn't have a dog in the fight and hasn't leaned one way or the other.
Everything that we've come in with.
Yeah, that's really interesting.
Yeah.
So, thank you.
It was really interesting. I just thought I'd call and share that. Yep.
I appreciate
Hopefully
it. We're going to start in just
soon,
moments. So have a great day.
Oh,
and
sure
look
we
forward
are.
to
We're
watching
gonna have a sidebar. Don't trick me. I know we're gonna have a sidebar, but I'm gonna hang up anyway. Okay.
Thanks, Legally Blonde.
Talk to you later. Love you guys. Bye.
Yeah, bye. That's a lot, and I have a lot of energy. She has a ton of energy. Christine E says this trial better not interfere with me getting my dinner ready in the crock pot. You know who you are. Weezer, thank you very much for the super sticker, my friend. Great way to kick off the morning. Let's see. Turtle Boy said on X the next 3 witnesses from the defense. That's cool. Well, at least we have 3 more witnesses, right? So we're not done yet. A couple of people I need to mention from this morning. Kelly H. gifted a membership. Kelly, thank you for your continued support. Mystic Mom, a member for 15 months, says happy birthday to you all. Tony Zamora, congratulations on the 7 months, Tony. Appreciate you. Amanda H., 25 months, genuine OG there. Christine E. with the super chat and Weezer with the super sticker. It looks like I got them all before, but a second mention does not hurt anyone. All right. So if you've seen the Candy Kiss, if you see the next 3 witnesses after Dr. Russell, let me know. It would be interesting to know what the order is. Who's the next 3? Let's see. Lucky, Karina K., and Officer Barros. All right, so Lucky is the snowplow driver. I'm trying to remember who Karina K. is. Don't remember off the top of my head. Officer Barros, I think it's pretty obvious he's law enforcement. But it's amazing to hear what an objective mind perceives. Mind not poisoned by YouTube groupthink. Yes. I think it was Peter Tragos yesterday. Was analyzing how we get so far into our rut of what we think is right that at this point for a lot of us, it's very difficult to see anything the other way or see it objectively. If new information is presented, it's very difficult to see it in a different light. Just because we've seen so much and we have such a strong opinion about what we've seen. Sherry, I'm running a little bit late. It's okay. I'll send you a note. Happy birthday. Everyone came in late, so we're going to rewind and listen to what the caller was talking about. I was lost. Oh, you're good. Kim R. says demonetization stinks. Starting the train choo-choo. Kim, thank you. Thank you very much. Demonetization happens in court cases. It's just something we realize that sometimes the content, as soon as we start our live stream, does not match what YouTube thinks the content should be at the beginning of the live stream. It's weird because if that happened an hour later, we would have been fine, but I guess not. I guess not yesterday. Play gray is the new green, says Baca. I think court's going to start. We're not going to have time to play the song here. I'm optimistic that Judge Cannone is going to be walking in moments, mere moments. All right. Okay. Today's Tuesday, so that you can't see us next Tuesday because we're here today. Lone Star, but I see what you did there. That's not the word that got us, because they didn't say it yesterday. It was the good old bomb. The good old bomb got us. By Brennan, I think it was. Brennan dropped the bomb. First, he said that he gave us the first letter, and then after that, he gave us the whole word, and that was enough at 43 minutes to tell YouTube, let's not advertise on this one. Okay. Josh, thank you very much for the sticker. We'll put on the top of the screen here the message, which we'll see when the witnesses start. Take the stand should be this one, barring some strange circumstance. Dr. Marie Russell will continue cross-examination. Let's see. You missed the cussing. It came during the text message reading, where the witness on the stand, a friend of Mr. Proctor's, was not comfortable in reading Mr. Proctor's words, and asked to not do them because they weren't his words and he wasn't comfortable. The judge gave the permission for Mr. Brennan to read the evidence in, which normally doesn't happen, but in this case the judge authorized it for that reason, because he didn't want to say those words. And Mr. Brennan edited out the worst of them and included some of them. So ads don't play on demonetized videos. If they do, YouTube just doesn't share revenue with me. It's my understanding they don't. That when I say demonetized, there are a very limited number of ads where the companies have authorized YouTube and said, we're okay with you playing our stuff on some of the edgier material. Generally, those ads are for things like alcohol, gambling, all the things that are addictive, which as a channel called Recovery Addict, it would be a little ironic for me to allow those types of ads. YouTube's actually reached out to me and said, hey, we think your channel would be really good for some of these more adult-oriented ads. I'm like, have you seen my channel? Do you know what my channel's called? So I've said no to that, so I don't think there should be any ads when it's demonetized. But there might be a few fringe companies that do get in. I hear Mr. Brennan is here. It's when swearing happens in the first hour of the live stream.
Hear ye, hear ye. All persons having anything to do before the Honorable Beverly Cannone, the Justice of the Superior Court, hold an indebtum within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
Good morning, counsel. Good morning, Ms. Reed. Good morning, jurors.
Good morning, jurors.
I have to ask you those same
three questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions given to refrain from doing any independent research or investigations? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about the case since we left yesterday? Everyone said no or shook their head negatively. All right. Love the judge. Love that intro.
If you want to.
Miss Joni Hockey comes in with 5 gifted memberships. Thank you, Purple Coconut. David Reed. I missed the other ones. Canadian Girl, Stacy Jarvis, Kathy Leverton. All gifted memberships by Miss Joni Hockey. Thank you. I can't believe you can repeat stuff like that the way she's talking. That's what I do when only I can listen to the sidebar and I can't let you hear it. For some reason, I can do that backwards.
Doctor, I remind you, you're still under oath. Thank you.
Thank you. Good morning, Dr. Russell.
Good morning, Your Honor.
I just like, please say yes.
May I?
Yes.
Good morning, Doctor.
Judge said yes.
Good morning, Mr. Brennan.
I had asked you yesterday if your opinions regarding the wounds on Mr. O'Keefe's arm changed between when you testified last year and then the more recent hearings that we've had over the past 4 or 5 months. Do you remember that question?
Yes.
And when I asked you that question, I asked if you had help with your report, and you told us that there was a woman who helped you with your report.
I told you that there was someone who helped me or made suggestions in organizing the report, having certain sentences placed in certain categories.
When I asked you about the identity, the person who actually helped you, I asked you if it was one of the attorneys, and you had said no?
That is correct.
May I approach, Your Honor?
Yes.
Apparently it was what, Ms. Little? She's an attorney.
May I ask a question?
Yes.
Thank you. You had testified in December 22nd, 2024 in this case?
I believe it was that date, yes.
And when you testified back in December of 2024, do you remember I asked you who it was that had assisted you with your report?
I don't remember that specifically.
Well, I'm going to show you a page from the testimony. This is from the hearing. And I asked you, line 21, page 207, did anybody help you write this report? And what did you say?
I wrote the report.
If you could finish, please.
I had some help with some minor edits, rearranging, some paragraphs or whatsoever, but putting things in the right category.
Then I said, okay. And you answered?
No, I wrote the report.
And then finally I asked, who helped you with your report? What did you tell us?
I said, Mr. Lessie.
And Mr. Lessie, is that gentleman the attorney who asked questions on direct examination?
Yes.
Okay. And so, did Mr. Lessie help you with your report?
What I recall is we discussed the report, but I recall that it was someone else. That's my memory right now.
Is your memory different now than it was last December?
Well, I don't think so, but, you have something in writing.
Do you think you would have testified to that if it was inaccurate?
Mr. Alessi did not help write the report. He may have helped organize and make a suggestion about what is training versus what is experience, but he did not help me write the report.
Did you have any help trying to describe methodology?
No.
Did you have any help talking about differential diagnosis?
No, I'm very familiar with differential diagnosis.
And so, after that report was written, is there any reason why some of your opinions have changed?
I don't believe my opinions have changed.
When you testified at the hearing last year, June 21st, 2024, did you express that you couldn't say with 100% certainty what type of animal, in your opinion, caused those wounds?
100% certainty? That is absolutely correct. And I'd like to see that, but yes, that's my recollection.
If it's your recollection, I'm happy to show you what
yes,
you
please.
testified to. You want to see it again?
Yes.
Okay. And by the way, between last night and today, did you get any advice from anybody suggesting you should ask for a transcript when I ask you a question? Did that advice come your way?
That's my general advice from previous times.
Well, did you have any advice last night about that?
Yes.
Who told you last night that you should always ask for a transcript when I'm asking you questions?
Well, I think it was just Mr. Alessi.
So did you and Mr. Alessi, you know there's a sequestration order, don't you?
Yes.
A sequestration order that you're not supposed to discuss the case at all with anybody?
Well, we didn't discuss specifics.
Do you know that the sequestration order mandates that you not discuss anything about the case from when you start your testimony until you end your testimony? You know that, right?
I understand that there is a sequestration order.
Do you understand the sequestration order mandates that you're not supposed to speak to people, including the attorneys, about this case overnight? Did you understand that?
There were no specifics discussed.
Well, did you understand that you weren't supposed to, is what I'm asking. Did you know that's a violation of the sequestration order to speak to the attorneys overnight?
I did not know that that particular conversation would be a violation.
So did you meet with Attorney Alessi last night?
No.
How was it that you had a conversation with him?
Actually, it might have been in the vehicle.
You drove together?
Yes.
So did you commute to and from court together with Attorney Alessi?
Well, there's a driver.
Okay. Who else is in the car when you left court yesterday?
The driver. No, I wasn't with him yesterday, no. Not in the car yesterday, no.
Well, you just said that you spoke to Attorney Alessi yesterday. And I'm trying to figure out when was it that you were having conversations with Mr. Alessi relative to the sequestration order that you're under?
This morning, riding to court.
Okay, so you and Attorney Alessi drove to court?
With the limo driver, yes.
Well, who was in the limo with you and Attorney Alessi on the way to court today?
That was just us.
Just you two?
Yeah.
What else did you both talk about other than that you should ask for a transcript every time I ask you a question?
That's what we talked about specific to this case.
Was it a long conversation?
No, not at all.
The entire ride here, there must be more you spoke about other than just the sequestration order.
We did. We spoke about Boston, how I love Boston area. We spoke about New York. We spoke about other things. And in fact, I have to say that even on the ride back to the hotel yesterday, with others in the car, nobody spoke about the case.
But I'm talking about this morning when you did speak about the case. What else? Not about the Red Sox or the weather. What else did you talk to Attorney Alessi about this morning other than you should ask for a transcript every time I ask you a question?
We talked about what I did last night.
About this case?
No.
I'm sorry, but I'm asking about this case.
That was it.
I want to know what all the discussions were between you and this attorney today or last night about this case.
Just that I should ask for a transcript.
Well, there must have been some concept. There must have been some context. He didn't just turn to you talking about the weather and say, hey, you should ask for a transcript. You must have been talking about something.
He also generally, not today, but generally says, be honest. Always be honest.
Fantastic. But this morning about your testimony.
Fantastic.
What did he tell you? Did he tell you this morning you should be honest?
Not this morning.
Okay. Does anybody need to remind you to be honest when you testify?
No.
Okay. What else did he tell? How did it come up? Hey, by the way, ask for transcripts.
I don't even know how it came up. I didn't put much significance to it.
Well, it was just moments ago it happened because you just got to court. You can't remember the context of the sage advice of Attorney Alessi?
No.
Do you have any memory issues?
No.
Okay. May I approach?
Yes.
She's offended. She's offended. Yesterday, when she asked for a transcript, Mr. Brennan
Since
stumbled.
you asked for the transcript, I have it for you.
Now she's going to ask for a lot of
Dr.
transcripts.
Russell, this is June 21st, 2024. I had asked you whether you expressed that you couldn't say with 100% certainty. You agreed with my answer, so there was no need to try to refresh your memory, but I'm going to show it to you because you asked. We can take a look at line 16. Is that now consistent with the questions I asked you and the answer that you gave, that you were less than, you couldn't be 100% certain?
That looks consistent.
You want more time with the transcript?
No.
He's going to keep rubbing in that transcript because you asked for a transcript. He's going to keep playing that card. He's going to pound on that note.
Has anybody else talked to you about your testimony today overnight, Dr. Russell?
No.
When you testified last year, same transcript that we just looked at, do you remember when you gave your opinion to a reasonable degree of medical certainty, you said that you thought the wounds were from an animal, possibly a large dog?
On that same date?
Yes.
May I see the transcript?
Of course. Pursuant to Attorney Alessi's advice, let me approach.
Objection, Your
Objection to the commentary.
Strike that. Disregard that, Jones.
May I approach?
Yes. What page you want us to?
23.
Told you he's going to keep playing that note. He's so mad at Alessi. I don't know if that's a violation. I honestly don't.
June 21st, 2024, Doctor?
June 21st.
If it is a problem, the judge will address it.
Page 23, line 14. Will you ask the question based on everything we've discussed today? Is it your opinion based on a reasonable degree of medical certainty these injuries were from an animal attack, possibly a large dog? What did you say?
I said yes.
Thank you. Have that back?
Yes, you may.
Okay, thank you.
She holds on to it. He's like, can I have it back? Oh my goodness. They're at war right here. We're watching a war.
When you gave your opinion, not this year, last year,
She's throwing daggers with her eyes.
you agreed when you were assessing the wound, you used the word or adopted the word possibly, didn't you?
Explain the context of it?
Sure.
That sentence?
Sure. Go right ahead.
No, you. I'm sorry.
Okay.
Then I'm sorry. Please rephrase the question.
When you were asked about your opinion last year, not this year, last year, about whether to a reasonable degree of medical certainty the injuries were from an animal attack, possibly a large dog, you agreed with that characterization. A large animal, possibly a dog, didn't you?
Yes, an animal, possibly a large dog, last year, yes.
When you were on direct examination, there were tons of questions about this word methodology. Do you remember all those questions you were asked?
In June?
Yesterday.
Yesterday, okay, yes.
Yes. And when you were asked about methodology, was that an attempt to try to explain that you weren't just looking at an abrasion and guessing or eyeballing it? You were trying to suggest some type of scientific or medical process to give some type of certainty to your opinion?
That is the process I used.
When you talked about methodology yesterday, you talked about your experience in methodology with knife wounds and gunshot wounds, correct?
Yes.
But there was no methodology whatsoever regarding looking at a photograph and then identifying whether that is consistent with dog bites, is there?
I disagree.
When you described methodology, you were asked by Attorney Alessi whether or not you've engaged in that methodology regarding dog bites. Did you agree that there is really no methodology regarding dog bites?
I disagree.
When you use the word methodology regarding dog bites, there isn't something specific you're looking at as if you were looking at a fingerprint. There are points of comparison. You don't do that, do you?
There are no specific points that are published by a organization, for instance, on how to determine something is a dog bite. However, I did use different methodologies, including what we talked about, the differential diagnosis, the pattern recognition. Pattern recognition, again, is so important in medicine. It's what pathologists use to diagnose tumors.
There is no standard. There is no recognized standard anywhere for methodology on how to identify a dog bite wound, is there?
There is no published standard from an organization that I am aware of.
So there is no source, there is no recognized community, there's no certification, there is no recognized method in identifying a superficial abrasion as a dog bite. Isn't that fair to say?
As in many conditions in the medical field, there are no certifications.
How about published standards? Is there any published standards whatsoever, any, regarding claims that a superficial abrasion is a dog bite? Are there any published standards by any organization?
No, but there would have to be thousands of published standards to identify the causes of the thousands of different types of abrasions. So no, there's no published standards.
No published standards. There is nowhere you can point to where the so-called methodology that you were telling the jury yesterday is a readily accepted standard in the dog bite community. You can't point to anywhere, can you?
There are peer-reviewed articles which list recommendations on how to determine something is from some wounds are from a dog. These are peer-reviewed articles written by esteemed physicians that have analyzed dog bites and have published these and have published an approach to identifying, particularly a forensic approach to identifying dog bites.
Let me ask you the question again, Dr. Russell. Can you point to one place where there is a readily accepted standard in the dog bite community for identifying dog bites? One article, one journal, one book. Can you point to any?
Well, I'm going to mention the articles I mentioned earlier. The article with the lead author of Dr. Demunick and the article with the lead author of Dr. Pollack. And although they're not standards, they are recommendations.
I'm going to ask you the question one more time before I approach. Can you point to one place, one, where there is a readily accepted standard in the dog bite community for identifying dog bites?
Objection asked and answered.
No.
And so with no readily accepted standards in the dog bite community, no defined methodology, when you look at a photo
how do you
like
become
you
a
do of
member?
John O'Keefe's arm, you're just eyeballing it based on your personal experience with dog bites rather than relying on some type of scientific foundation that has been published and accepted in the community.
Objection, Your Honor. I'm going to allow that.
Isn't that fair to say, Dr. Russell?
No, absolutely not. There are many, many conditions in medicine where there are no standards developed, and yet doctors make, and nurse practitioners and the like, make diagnoses all the time on these various medical conditions, and more importantly, they treat them because they require treatment. There are not published standards on every single of the 10,000 or more medical conditions that exist, including dog bites.
I'm not talking about a stuffy nose or a broken leg. We're talking about dog bites here. So let's focus on dog bites, if you would, if you can indulge me, doctor. Regarding dog bites, since there is no standard practice, there is no accepted methodology, and since there is no accepted and approved guidelines, you are essentially simply looking at a picture, a photograph, and just using your past experience with treating dog bites as the basis for your opinion. Isn't that fair to say?
I don't think so. I'm using my past experience, my strong interest in dog bites over 30 years, and the methodology and the articles that I read. The numerous articles I read, but the articles that have recommendations. I'm using all of that combined to come up with a methodology for determining that those are the result of a dog.
When you say coming up with a methodology, are you saying that you're creating your own methodology, that you're the person who has the standard and nobody else? Is that your position, Dr. Russell?
No, the phrasing was not good there. I use standard methodology of pattern recognition and differential diagnosis.
There is no standard in the medical community relative to differential diagnosis and pattern recognition as it relates to dog bites, not other areas of medicine, dog bites. There is no accepted methodology, is there?
That's true.
You mentioned that you have this strong interest in dog bites. Let me borrow a phrase. Do you think you had any confirmation bias when you got into this case?
I don't think so.
Well, you definitely wanted to be in this case. You weren't sought out, you sought the case.
That is incorrect.
And you said you had a strong interest in dogs, and that is one of the reasons you wanted to get involved in this case. Isn't that fair to say?
No, that's actually an unfair statement. I did not want to get involved. I wanted to offer my my knowledge and experience to help clarify issues. I did not want to become an expert witness in this case. And I used, again, as I do on just about every medical condition that I look at and every wound that I look at, I do a differential diagnosis. What else could this be? What else could have caused these scratches and abrasions and wounds? What else before I come to my conclusion?
On your ride over here today, were you instructed that when I ask a question, rather than answer it, give a long explanation about something else?
No.
I would like to put up an exhibit of Mr. O'Keefe's arm.
David,
and I want to ask you some questions about it. You and I have had many conversations about Mr. O'Keefe's superficial scratches before, haven't we?
Yes.
And would you agree, looking at these, they are superficial abrasions? Do you agree with that characterization?
Yes.
When we last spoke, just for background, to remind ourselves, we broke these into separate parts so we could discuss them by number, just for the sense of clarity. And we discussed this as wound number 1. Do you remember that?
Grouping number 1, yes.
Number 2?
Yes.
Number 3?
Yes.
4?
Yes.
5.
Which did you call 4? 4, 5, 6, maybe.
Okay. So as we go through, I'm going to identify them by number. That wasn't done by anybody else. It was just during our discussion so we can have clarity. Is that fair?
Okay. Sustained.
Is it fair if I refer to this as 1, 2, 3, 4, 5, 6?
I think so.
Okay. When you testified on June 18th of 2024, last year, when you came in, you were asked questions before the actual hearing. You were asked questions about this particular superficial abrasion, weren't you?
I'd have to see the transcript. I believe so, but I'd have to see the transcript.
Do you remember when you were first giving opinion testimony about this specific abrasion, wound number 1? Do you remember you saying that you thought it was either teeth or nails?
I'd have to see the transcript again.
I will give you the transcript, and as I'm doing that, let me ask you, do you remember your testimony about what you actually said?
I don't remember the exact words.
So, do you remember your testimony?
For each specific day, no. I remember generally, but not for each specific day.
If you
I've
have
been here many
opinion,
times.
I'm going to bring your transcript up to remind you, but if you have an opinion, it shouldn't change, right? It should always be the same?
Objection.
Generally, yes.
Okay. So let me ask you before we talk about what you said at the beginning.
What's your
What is
opinion
this
now?
from? Teeth or nails?
It could be either, but I think that's from teeth.
So when you say they could be either, if you have a methodology and you have a certain standard where you can identify something based on a standard, there wouldn't be so much uncertainty, would there? You'd be able to look at this, consider the methodology, and either come to an opinion whether it was teeth, nails, or something totally different, right?
You know, Mr. Brennan, perhaps I didn't explain earlier, but the nail of a dog tends to be cone-shaped, conical in shape, and very similar to the nails that the canine teeth of dogs. So the shape and the fact that they come to a point makes some wounds indistinguishable.
Are you saying that nails of a dog are so similar to the teeth that you can't tell the difference between them when you're looking at a wound?
I'm saying that they can cause similar-looking abrasions.
Are you able, as the premier expert in the United States on dog bites, able to tell the difference between teeth and claw nails of an animal when you're looking at a wound?
Individually, well, okay, that's a very interesting question. Sometimes it's difficult because they can have similar appearing wounds. So you have to look at the overall pattern in order to make some conclusions.
Well, when you first started testifying in this case, you never suggested you had to look at everything in totality. You were giving opinions regarding individual wounds. Isn't that fair to say?
No.
It wasn't until I began asking you questions and you had inconsistent answers that you've now changed from, rather than identifying individual wounds, now you're saying I can't identify individual wounds, but I can tell you in totality.
I disagree with that. I believe that the very first time I testified, I mentioned that the overall pattern was important.
When you first testified, so today, before we get to your testimony, you're saying this could be either teeth or nails, but you think it's probably teeth.
Correct.
How probable? Do you think it's certainly teeth, to a reasonable degree of medical certainty? You're not sure? What is the value of your certainty or lack of certainty about what caused this wound?
Reasonable degree of medical certainty.
What is a reasonable degree of medical certainty? That what?
That those are caused by teeth.
Teeth. Okay.
Last time
when
she
you
said
first
scratches.
testified, your position was it could have been teeth or nails. That is different than saying, to a reasonable degree of medical certainty, teeth, isn't it?
No, there is a small possibility that they could be caused by nails.
When you first testified, you didn't qualify it as a small possibility, did you?
I perhaps wasn't asked.
Well, you answered. Remember when you were asked about it and you answered? You talked about that it was a pattern close to the shoulder with parallel marks. Do you remember?
Do I remember what?
Saying that this is a pattern close to the shoulder, right? That they're superficial. You agree with that still?
Yes.
And did you say they were consistent with teeth and nail marks?
Yes.
Okay. Nails on a dog oftentimes or most times are horseshoe shaped, aren't they?
They're generally conical shape.
You don't think that nails on a dog in your studies have a horseshoe shape?
I think it depends on the grooming of the dog and if the nails were cut recently. But in general, they come to a point. They're at the, at the end of the paw. They come to a point. And by the way, the paws can open and close. So the distance between the nails can vary depending on how that claw impacts the skin. So in many ways, they resemble the overall shape of canine teeth.
And so to get back to my question here, you're saying that this could have been caused by dog nails?
It's possible.
Do you know, or do you think that the teeth in a dog are different shapes and sizes?
Oh, yes. Depending on the tooth, there's different shapes and sizes. Absolutely.
When you testified the first time and you said that you thought it was teeth or nails, do you remember testifying a couple days later in front of a group of people and you again iterated that this could be teeth or claw marks? That was your testimony last year. Teeth or claw marks, right?
Your Honor, I'm going to object to the characterization of that prior proceeding.
So just prior proceeding, folks, that's all that we need.
Did you testify at that prior proceeding last summer that this could have been teeth or claw marks?
I would need to see the transcript.
He doesn't want to give her the transcripts because he wants to do this with every single one of them. He wants to just give her the part for that one specific line, not have her read the whole thing. Look at everything she testified to.
May I approach?
Yes.
When you first testified on June 18th, Doctor, you were asked questions trying to identify what you thought that wound was. And this is your June 18th, 2024 testimony. On page 37, line 7, the questions begin. when you were asked what you thought they were, you can read any part you want, but line 7 might be a starting point.
Yes, I said that which are consistent with teeth marks. They also could be possibly consistent with nail marks.
Dr. Russell, I'm just going to ask you to keep your voice up, okay?
Okay. Let me see.
Thank you. That was your first testimony last year, yes?
Yes.
And then did you testify a couple days later and again repeated the same opinion, teeth or nail marks?
May I see it?
I'm asking if you remember.
Yes, I remember testifying.
Do you remember after you worked on your report and submitted your report?
Yes.
After your consultations, do you remember changing that opinion regarding number 1? Do you remember changing that opinion?
No.
Do you remember changing from either teeth or possibly claw marks to being very specific, claiming that it was definitely teeth marks?
No.
Are there different types of teeth in a dog?
Yes.
Okay. The pointy teeth, the big ones, those are called canines?
Correct.
And the smaller ones are incisors?
Correct.
There are 6 incisors in a healthy dog on the top and bottom between the canines?
Correct.
Okay. Did you, when you testified subsequently to the original proceedings, did you change your opinion from teeth or claw marks to specifically teeth and even more specifically canines?
Do you have a transcript?
I do, but I'm going to ask you the question. Do you remember changing your testimony from teeth or nails to being very certain that it was canines, not just teeth, canines that caused that wound?
I became more certain, yes.
You had never said that the canines caused these wounds before you filed the report, ever, did you?
I may not have, that's true.
And so after you did your report, you shifted from teeth and nails to canines. Do you remember that?
Canines are
I don't
teeth.
think it's a shift.
No one would ever refer to a dog's nails as canines, would they?
No, I don't think so.
That would be inaccurate, wouldn't it?
Yes.
That would be a mistaken use of the word.
I believe so.
When you testified December 2024, you didn't say nails could have caused this wound. You didn't say generally teeth. You said canines.
I believe that, and that's true. I believe that canine teeth caused that wound.
Did you have any new information about photographs that would help you change your opinion from teeth and nails to canines?
Well, I had been challenged. I had testified several times. I reviewed the case several times and challenged, and each time I reviewed the case, I became more certain that these were from canine teeth. And actually, there's other marks there, but these are from teeth.
You say more certain. You had never said canines before, ever, until that recent hearing. Isn't that true?
I said teeth.
Canines.
It doesn't matter. I said teeth. Canines are some of the teeth.
Upper or lower canines?
Upper.
And if it's upper canines, you testified previously that the point of entry would be here at the bottom and the dog would pull this way. That's what you testified to. Yes?
No, I believe you misunderstood then. The point of entry is up there. The first initial point of contact is there, and the dog pulled this way, or Mr. O'Keefe pulled his arm the opposite way.
Dr. Russell, you don't recall that you said that the bigger circles are the point of entry, the dog pulled this way, and then I asked you, how could a dog pull this way when the arc is like this? The dog's mouth would have to be in backwards. Remember that conversation we had?
Objection, Your Honor.
I'm going to allow.
Do you remember that conversation? You said that the point of entry would be the bigger circle pulled this way, and then I questioned, how could a dog's arc look like this if the teeth went that way?
No, I don't recall that at all.
Remember that conversation
No.
we had? Okay. And so, inevitably, when you look at this part of the wound alone, have you expressed an opinion that you're unable on its own to be able to tell whether this was caused by a dog?
Which part of the wound?
Taking any of these alone, let's start with number one. Haven't you expressed an opinion that taking this alone, you would not be able to say that was from a dog bite?
That is correct. In and of themselves, they're not that specific or characteristic. However, as a group, they are highly characteristic of a dog
So if
injury.
Mr. O'Keefe's arm only had this wound and nothing else, by virtue of what you're telling us, you would not be able to offer an opinion that this was consistent with a dog bite.
That very first wound up
Yes.
there, closest, I agree. Yes.
In fact, you've testified about this very issue before. If this was the only wound on Mr. O'Keefe, number two, you would not be able to say that the injury is consistent with a dog bite.
Correct.
I'm going to go through all of these just so we're clear. Same thing with number three. You've provided opinions on this before. If you look at this wound alone, in isolation, you would not be able to say that it came from a dog bite.
Correct.
Four, pardon me. Yep. Four, same. Looking at the wound alone, you would not be able to say it came from a dog bite.
Correct.
Same for 5 and same for 6.
Correct.
Now, when you testified before your recent testimony, you never had that qualification. When you came into court, you were saying that when you looked at these wounds individually, you were saying that you could identify it as a dog bite.
I disagree with that characterization.
Number two, what caused this wound, Dr. Russell?
Number two, I believe that was dog bite or scratch, but mostly I believe dog bite. And because there's a punctate, little tiny, pinpoint almost, lesion there and there, which could represent bottom teeth.
Okay, so you're using words like could, and we're talking about a reasonable degree of medical certainty. So when you look at this wound here, you said that you are sure or not sure what caused this wound.
I'm saying that individually, that wound, that's correct. I'm not sure individually what that wound was caused by. However, again, as I mentioned earlier, the overall pattern of wounds is what I am convinced of.
I want to go through each of these wounds separately so we understand what you actually recognize with your methodology and what you don't. So looking at wound number 2, based on whatever methodology you've been using, are there any signs, indicators, objective criteria you can look at and tell us this is or is not a dog bite based on this methodology you have?
There are some characteristics that are suggestive of a dog bite or dog claw, including the fact that there are parallel lesions, and many of these, overall, by the way, parallel lesions are in the same general direction. So there are parallel lesions, and here they're associated with some punctate or point-like other abrasions right here. So they're consistent with being inflicted by a dog.
I appreciate you using some medical terms to describe this, but my question is more pointed. Is there anything about your methodology, something that stands out about these wounds that you can say to a reasonable degree of medical certainty that these are consistent with a dog either biting or scratching?
These wounds all by themselves, not to a medical degree of certainty, no.
You said on this first wound you thought this was from the canines. Those are the big upper teeth is what you're claiming, right?
Yes.
And you're saying today, anyways, starts here at the bottom and goes up. Is that your position today?
That's not what I said. I said the exact opposite.
So it starts here and comes down?
Correct.
Okay. And these two scratches, they're linear, just like these are linear, aren't they?
Yes.
But you have a problem with these because if these are the canines, you see the spacing there?
Uh-huh.
This is nowhere close, is it?
I didn't say that these were caused by canines. And spacing also, there's reasons why the spacing could be different.
Well, we can talk about that in a second. Are you suggesting that these exact, well, not exact, these two linear abrasions, just like 1 and 2, are you suggesting the canines caused these?
I don't know what caused those, which teeth caused those, or which nails caused those.
When you testified last year on June 18th, you said that this was either teeth or claws. Can you give us any development of your opinions, whether or not you think that is teeth or claws?
Excuse me? No, well, I couldn't hear because of the fan.
When you testified on June 18th, you said wound number 2, the top 2 linear abrasions, you believe were either teeth or claws. You've shared with us now you have improved your study and have new opinions. Do you have a clearer opinion whether this is teeth or claws?
Objection, Your Honor.
Sustained, ask it differently, Mr.
Do you have an opinion whether this is teeth or claws or not something totally different than a dog?
I believe they are teeth or claws caused.
When you testified at trial and in that hearing that they were teeth or claws, you changed that opinion as well at the most recent hearings, didn't you?
No, I'm going to object to the worded use that's been done before.
Mr. Brennan, word it differently.
Sorry?
Word it differently.
Okay. Did you testify at a more recent hearing that teeth made these, not teeth or claws, but teeth?
I may have, and I would like to see that.
May I approach?
Can you just hold 1 second? Could you please turn the fan off, Paul? Jurors, is it okay if we turn the fan off so we can hear better?
All the jurors said no or shook
Thank
their
you
head.
very much, Officer Dillon.
May I approach?
Yes.
From your December hearing, page 100, line 5, when you were asked about that second wound in December, and I asked whether you changed your opinion from teeth or claws to just teeth, weren't you asked specifically about that on page 100, line 5?
Yes. But may I read it?
Sure, I'll read it with you.
Okay. I said, I'm not sure on the second set. So this is the set just above the elbow.
Mm-hmm. I'm not sure exactly what teeth made these. They could, one of them could, one set of these could be canine, one part of this, and then adjacent incisor tooth. But I'm not sure on the second set, so this is the set just above the elbow.
Yeah, I think the first part of that paragraph is talking about the first set. Yes. up there close to the shoulder, and then the sentence, but I'm not sure on the second set, so this is the set that's just above the elbow. I said I'm not sure.
And then, sorry.
Go ahead.
Are you done?
Oh. Yeah, actually, I did make another comment. What is it? So, however, what is interesting and certain is that there's an upper set and a lower set. So, This mark was an upper tooth. This is a lower tooth. What I was referring to is this mark here and that mark, and then this mark here and this mark here. So it appears that this is from upper and these are from lower. That's what I was referring to.
And so when you first described this wound as teeth or claws, at the most recent hearing, you had a certain opinion that this was teeth, didn't you?
Yes, I was leaning towards teeth. Correct.
Well, it didn't seem like you were leaning. You said these were from the upper teeth.
Yes.
You said it matter-of-factly, not with any qualification. Your claim at the last hearing is this was from teeth.
That's what I believe.
And today you're saying you don't know if these were teeth or claws.
Not with 100% certainty.
You didn't qualify 100% certainty. You were asked your opinion, Dr. Russell.
Yes.
You were asked, what do you think? And you didn't say, well, not 100% certainty. Your claim, the first time you testified, teeth or claws. Recently, you said teeth, and now you're saying you're not sure.
No, I'm saying I believe that those marks are from teeth, but I'm not 100% certain.
Suffice to say, looking at wound 2 alone, you cannot say this was caused by a dog.
In and of itself, no.
What tooth do you think caused this wound?
I don't know.
Do you think this in any way could be caused by dog teeth if you're claiming that this is dog teeth?
Excuse me?
Do you think there's any way these two could be caused by dog teeth if you're saying that these two were caused by dog teeth?
Yes, it could be, but I don't know which teeth. And I don't know the extent of the bite, how much impact there was, and how much pressure, how much contact there was between the teeth and the skin.
The canines are the longer teeth in a dog's mouth, aren't they?
They are.
And when a dog bites, it's very common for the canines to puncture, isn't it?
It's common if there's enough force, and it's common that you might have two canines if the strike is perpendicular to the skin. But if you have a tangential strike, a partial strike where only part of the teeth impact, you'll get different configurations.
Look at the spacing, Dr. Russell.
Did you say strike or strike?
Strike with a K.
Look at the spacing, Dr. Russell.
Mm-hmm.
A dog causing these wounds, the canines are not going to have such a dramatic distance between them because dog canines don't move, do they?
They don't, and I'm not claiming that these two parallel stripes in this case, or abrasions here, I'm not claiming that those two were caused by canines.
You think a dog is going to leave a wound with linear abrasions using its incisors as opposed to its canines? Is that your opinion?
It's possible if that's the only part of the mouth or the jaw that actually touched the skin, if it didn't go back as far as the canines.
Did you ever look at the underside of Mr. O'Keefe's arm?
I did.
Posterior side?
Excuse me. Pictures, yes.
Yeah. And when you looked at the photographs of the posterior side of Mr. O'Keefe's arm, did you find anything conspicuously absent from underneath his arm?
Well, first of all, let me clarify. Part of this is the posterior aspect of the arm. So are you asking me, did I look at the underside of the arm, the fleshy part of the arm?
Exactly what I'm asking. It's a question I've asked before. When you look at the other side of Mr. O'Keefe's arm, did you notice anything conspicuously absent?
Yes, there's an absence of wounds.
When a dog bites, I don't care if it's a law enforcement dog or a domestic dog, you know it's like a lever, a dog's mouth, isn't it?
It can be if both jaws strike the skin. However, there are many times when only the upper jaw strikes the skin.
The lower jaw is a lever, locks, and that's part of the clamping and pulling process of a dog, whether it's a law enforcement dog or a domestic dog. You know that, don't you?
I know that they are attached.
Your claim is that there's many, many different dog bites on Mr. O'Keefe's arm. Are you suggesting, to a reasonable degree of medical certainty, that these are a number of different dog strikes, and coincidentally, every single one of them lacks any wound to the underside of his arm?
Yes.
Your claim is that a dog penetrated the sweater on the top, but the lower jaw did not leave any wounds?
I'm claiming that that's not what I'm claiming. No. As I mentioned earlier, these could be from lower jaw. Those right there.
You're saying could be.
Could be.
That's speculation. We're asking you for your medical opinions. Your medical opinions. Do you have any evidence that the dog's lower jaw, you said maybe upper, maybe, that the lower jaw, even just once in this whole event, penetrated Mr. O'Keefe's skin?
No, nothing penetrated the skin. There was no actual penetration of the skin. These are abrasions. But I believe that these small marks right here, punctate marks, may be the result of lower jaw impact.
Rather than deal in speculation and maybes, can you tell us to a reasonable degree of medical certainty whether or not this was caused by a tooth?
Yes, Your Honor.
We're going to strike the first part. Why don't you ask the other part?
Can you tell us to a reasonable degree of medical certainty whether this superficial abrasion, put that back up please, was caused by a dog?
In and of itself, that part only, no.
Can you tell us anywhere on Mr. O'Keefe's arm to a reasonable degree of medical certainty where the lower jaw impacted Mr. O'Keefe to leave even a scratch?
Not with a reasonable degree of medical certainty on individual wounds.
And not just individual wounds, I'm talking specifically the lower jaw. Can you point to one wound, one abrasion on that arm where you can say to a reasonable degree of medical certainty the lower jaw caused any of those abrasions?
I believe there are several areas where there's impact from the lower jaw. However, I cannot say with reasonable degree of medical certainty that part only.
Let's look at number 3 to move along. When you first talked about these wounds, again, is it fair to say that you described that it could have either been teeth or claw?
I'd have to see it.
Okay, I'll bring it to you. You don't remember that testimony?
I remember, again, I've been here many times, so I want to be
Well, you have the opinion today, and I'm getting the transcript for you, Dr. Russell.
Thank you.
Do you have the opinion today that that those were either teeth or claws?
Yes.
What's your opinion today?
Well, I think that most likely they are from teeth marks.
Well, rather than most likely, we deal with reasonable degree of medical certainty. To a reasonable degree of medical certainty, can you give us an opinion regarding the cause of those marks?
Objection, Your Honor.
So I'll strike the comment.
Can you tell us to a reasonable degree of medical certainty whether these wounds were caused by teeth or claws?
Individually, no.
Did you ever change your mind about the source of these abrasions?
Can you be more specific?
Did you ever claim that any of these abrasions were from upper or lower teeth?
I don't recall changing my mind.
You don't recall if you've ever said that? Let's separate these bottom wounds. Do you have an opinion to a reasonable degree of medical certainty whether these were caused by teeth or claws?
I have an opinion.
To a reasonable degree of medical certainty?
No.
Do you have an opinion to a reasonable degree of medical certainty whether these were caused by either a dog teeth or dog claws?
I have an opinion.
To a reasonable degree of medical certainty?
Individually, no.
The one near the wrist, you had testified yesterday, there's lines in what you believe to be an arc, correct?
Yes, they have a general overall appearance of an arc.
If there's an arc and there's two linear abrasions on the outside borders, wouldn't these necessarily have to be the outside borders from canine teeth?
Not necessarily.
They're longer than the middle ones, aren't they?
The abrasions are, but doesn't mean the teeth are.
If this was an arc, like you claimed, you think different teeth other than the canines could have caused the outside scratches?
It's possible.
And you do note the distance between the top and bottom of those wounds compared to the distance in number 2 and the distance in number 1.
I see the difference, yes.
And you have to concede, Dr. Russell, that the same set of teeth, the same canines, could not reasonably have caused this wound, and this wound, given the distance between the inside and outside.
First of all, I'm not certain that these are all canines, as I mentioned earlier. Secondly, you have to take into account that skin is elastic. It bends. It depresses. So you could have two prongs, for instance, of a pitchfork, for instance, just as an example, impact the skin in different places, and the measurement between the two can be slightly different depending on the elasticity of the skin and the underlying structures.
This is not a slight difference, Dr. Russell, is it?
Again?
Objection, Your Honor.
So there was a question at that, so I'm going to let that in.
Again, Dr. Russell, the distance here, it's not insignificant, is it?
Mr. Brennan, I already mentioned that I did not think that these were caused by two canine teeth.
And these, the distance between these two, have you measured them?
I approximated them, yes.
What did you come up with?
Visually, and I can see that there's a difference.
What was your measurement for this one?
I think about 4 centimeters, and this was a little bit more.
Did you note that in the report? Did you
No, I did
measure
not.
them? Did you actually take out a ruler, measure them, and document them as you studied these wounds? Did you go through that process during your methodology?
No, because this is an image, and there's no scale in this image as to how far away different points are. So my own measurement would not be accurate because there's no scale in the picture.
Why did you go through the process of measuring them if you're now saying that it's inaccurate after I asked you if you memorialized it? Why would you even do it if you're now saying it was inaccurate?
It was an approximate measurement in my mind.
In your mind?
Yeah.
Okay, but you never put it on a piece of paper, a report, notes?
That's correct.
Why would you even go through the process if you're looking at it and your explanation is it's only a photo, I wouldn't be able to tell? Why would you even try to?
I think probably everybody in this room has already done the same thing.
And if anybody in this room did the same thing, it would be quite obvious, Doctor, that the gaps between 1, 2, and 5 are dramatically different from each other, aren't they?
They are. However, I'm not saying the same exact teeth caused those marks.
When you testified yesterday, you used the term differential diagnosis. I want to ask you a lot of questions about differential diagnosis. Do you remember using that term?
Yes.
And differential diagnosis was really just a way for you to try to get your opinion to the jury that these injuries were not consistent with the car accident. That's what a fancy way of doing it is, right?
No, it was a method I used.
Differential diagnosis, you're claiming that you can say this is not from a car accident or a car collision. That's what you're trying to say, aren't you?
That was the result of my differential diagnosis and my pattern recognition methodologies.
If you're going to exclude a cause of the injury, in this case, a collision, you have to know a little bit about collisions, don't you?
Yes. I don't know how to answer that.
Well, try.
Can you be more specific?
If you're going to say that these superficial abrasions could not have been caused by a car collision, you kind of have to understand a little bit about the mechanics of a car collision, don't you?
Actually, I disagree. However, I've treated thousands of victims of motor vehicle accidents and have seen the wound patterns that they come into the emergency room with, and that forms a basis for me.
Do you really think?
I'm sorry, please.
Did you finish that answer, Doctor?
No.
Did I cut you off?
I believe so.
Oh, I'm sorry. Please continue.
No, and the thousands of victims of motor vehicle accidents, I've looked at their wounds, I've treated their wounds, cleaned their wounds, touched their wounds, and that is what I use as a basis, part of my basis, to determine that these were not caused or not consistent with a motor vehicle accident.
When you first gave that opinion that it wasn't consistent with the motor vehicle accident, it's fair to say you didn't have a lot of information at that time when you first came in and said that, correct?
Specific to this case?
Yes. Yes.
I didn't have a lot of information, that's correct.
Okay. And so in order to rule out a collision causing these wounds, let me ask you, are you an accident reconstruction expert?
Reconstruction? No.
Did you ever go to any academy for training to receive any type of degree or certificates in car collisions?
Actually, I did receive a certificate in hit-and-run accident investigation from the Massachusetts Criminal Justice Training Council when I was a police officer.
Do you agree that what training you did have was rudimentary?
It probably was, yes.
Well, not probably. You've used that word before. Wouldn't you say that any training you have had has been rudimentary?
In terms of accident
yes.
investigation? Yes.
Have you ever testified as an expert anywhere in accident reconstruction?
No.
Do you know what ACTAR is?
ACTAR?
Yes.
No.
It's a certification group for collision specialists, accident reconstructionists. Is it fair to say that you're not ACTAR qualified?
Objection, Your Honor.
I'm going to sustain the objection.
Are you ACTAR qualified?
No, and I don't know any physicians that are.
Have you ever gone to a scene of a car collision and done an investigation and written a report and reached a conclusion about the cause of the car collision and the injuries that were related to that car collision?
No, that's outside my scope.
It's beyond your expertise.
Beyond the expertise of a physician, yes.
Right. Yet, yesterday, you offered the jury your opinion that these wounds were not consistent with a car collision. Did you offer that opinion yesterday?
Wounds are in my area of expertise. So, yes, I am very comfortable talking about wounds from a variety of sources, including motor vehicle accidents.
I'm sorry, I didn't want the siren to interrupt you.
Okay. Yeah, wounds are definitely within my area of expertise.
When you considered your opinion to this jury that this was not caused by a car collision, do you know what type of vehicle is in question?
Yes.
Have you ever studied the vehicle to look at the make, model, the height of different things like the bumper, perhaps the taillight? Have you ever studied that in this case?
I'm aware of some of those factors.
Have
yes.
you studied that before you gave this opinion? Yes. Did you go and actually look at the photos, do any measurements before you came up with this opinion?
Not before I came up with the opinion, no.
Did you ever look at the damage to the rear taillight of the defendant's vehicle and see if it was in similar or the same height of Mr. O'Keefe if he was standing up? Did you ever do that?
I have looked at photographs.
And when you looked at the photos, did you see that a 6'1" man like Mr. O'Keefe, if he stood, his elbow would be the exact height of Miss Reed's broken taillight? Did you notice that?
I noticed that there was a similar, that the height would be similar. The height of the elbow and the tail light, yes.
Did you look at photographs of Miss Reed's broken tail light and see if where the break was corresponded closely or directly to the same height as Mr. O'Keefe's elbow and forearm?
I did.
And did you see that it matched up height-wise perfectly?
Close, yes.
You have really no, respectfully, comprehension about the details of the car collision in this case, do you?
I have some understanding of the allegations of a possible collision.
Do you know how slowly or fastly Miss Reed's Lexus was traveling on January 29, 2022 at about 12:32 a.m., right around the time that you think these wounds happened?
I have some knowledge of the alleged speed at the time of the alleged collision.
Do you have any knowledge about the surroundings, the outside, whether the ground was soft or frozen?
I understand that there was snow on the ground.
How much snow do you understand was on the ground when Mr. O'Keefe's body first landed on that ground?
Several inches.
Where did you get the information that there were several inches of snow on the ground when Mr. O'Keefe landed?
You asked me when?
Where did you get that information from?
A report that I read.
Have you ever seen the videos or the reports that when Mr. O'Keefe was moved from the ground, there was grass and dirt under him?
Yes, I saw a picture.
Okay. Not 2 inches of snow. The ground, the cold, hard ground. Did you see anything that said that?
Yes, I saw an area of grass in the picture.
Have you ever looked at Mr. O'Keefe's pants to see if there was any dirt or grass stains on the back of them?
I've seen pictures.
Did you realize when you were forming your opinions about the source or the genesis or the cause of these abrasions, did you look at his pants and study whether or not he landed on snow or landed on the hard ground?
I did not see any evidence of grass on the pants.
Did you ever actually look at the pants?
I don't know if I looked at the pants.
So when you say you didn't see any evidence, are you saying you didn't look, or you looked and you didn't see anything?
I looked at pictures of the clothing that was available at the hospital.
Did you look at anything about the pants, photographs, the actual pants themselves? Did you look at them?
I looked at the pictures that were available at the hospital of his clothing that was on the floor.
Were part of the photographs that were available for your review and your conclusions of differential diagnosis, was part of that evidence photographs of the back of his pants?
I don't recall.
If you're going to make an opinion about something outside your expertise, that this was not consistent with a collision, wouldn't you want to see as much information as possible?
So let's, yes. We'll come to sidebar, Mr.
Mr. Brennan has pushed this quite a bit, unless he's had enough. If you want to form an opinion about something that's outside your expertise, yeah, that's the parts he's objected to. But I am enjoying this testimony as I eat my goldfish cinnamon roll flavored crackers, which I was going to save till the podcast this week, but they're so good. They're so good. Oh my goodness. Depending on how you view the case, you may think that that Mr. Brennan is not making any headway, or you may think that this is a home run for him. I personally feel that Mr. Brennan is more comfortable cross-examining witnesses than he is on direct. This is more of his element as far as his skill set goes. He might get into trouble with the level of snark he keeps bringing in. There's been a lot of sustained objections. There might be even an instruction given to the jury at this point. But this is exactly what we saw previously with Mr. Brennan and this witness. So we knew this was coming. So for me, it's not as surprising. Let's see. I think there's a little bit of him trying to twist her words, saying, but you said it was teeth before, and now you're saying it's canines. I don't think the jury cares about that so much because canines are teeth. But the more he can point out the differences of where she was fairly certain before or where she's fairly certain now, that might be a little bit effective. But every time he asks these questions about what about this mark, area 2, area 3, area 4, area 5, as he asks the questions and says, could these be canine teeth? Literally, the jury's looking at, trying to put the dog mouth on the arm and thinking, maybe. I can. It would have to. How would the dog have to be? Instead of trying to say, "Is this?" They're trying to match up the dog bite So I think that might be biting him a little bit. So if I can use that analogy. Let's see. These are so good. Why'd you have to bring up those goldfish? I thought I bought 3 of these. Like I bought a 3-pack after the podcast. Thomas told me about them during the podcast last week. And I bought a 3-pack, but one of them was a vanilla cupcake, one of them was strawberry shortcake, and only one was cinnamon roll. The cinnamon roll is the best by far. And I thought they would be good as a breakfast cereal, but they get soggy after about 4 seconds. So you have mush. Good tasting mush, but mush. Not my favorite way to eat cereal. I wonder if she regrets offering her experience and knowledge. I think she might have regretted forming a very firm opinion early on, or stating a firm opinion early on, because she's hasn't been able to remember or testify identically throughout the case. I'm talking about all the hearings on this. Looking at these injuries, though, and Mr. Brennan casting doubt on whether or not they are dog bites, you look at them and you have to say, okay, but the alternative that we have to consider and say, is this an option, would be the sharp pieces of a broken taillight at 24 miles an hour on a 6,000-pound car and a 200-pound guy. Would they cause these scratches or something more significant? Because there was no depth to any of these. How do you have enough impact to break the taillight, shatter it in all those pieces, cause cuts, cause abrasions, throw his body, as the state says, throw his body 7 to 11 feet, I don't know, back onto the yard, but only leave abrasions on the arm. It's a tough one to explain with either scenario. Lee, member for 28 months. Lee, OG. Did he ask Welcher how taillight caused each scratch? Onus of proof is on the Commonwealth. She probably didn't expect a second trial either. Yeah, she thought she was one and done. No, you caused me to buy Old Bay goldfish, not doing the cinnamon roll, but you don't regret the Old Bay, right? I wish I had bought more. I can't find them anywhere. I'm searching. I need the big boxes, and I just cannot find them. Mavia, thank you very much for a super chat. Says, I don't get why it matters, teeth versus claws. Either still means Chloe was there and inflicted an injury. She's not the killer. The car bit John. Mavia, thank you for that. I was trying to come up with a creative way to poll the chat about the injuries to the arm, but I don't want to. I was going to say the taillight bit him or the dog backed into him, and you had to choose between the two. But I guess I'll post that one just with those 3 options.
Dr. Russell, before you gave your opinion to this jury, suggesting that Mr. O'Keefe's wounds on his arm were not caused by an impact with the motor vehicle, did you go to the scene of 34 Fairview and look around in the corner of the yard?
I did not need to.
Did you?
No.
Did you look at photographs to see if you could identify the land, the dirt, whether it was flat and smooth or whether it was bumpy, whether there was rocks or debris in that area?
Yes.
And you went there and looked at it?
No, you asked me if I looked at photographs.
When you looked at photographs, did they show whether that ground had any bumps or divots or rocks?
It showed that there was a little bit of a hill in that area.
Could you tell from the photos, were they close enough so that you could see what the makeup of the ground was?
No, most of the ground was covered with snow.
Did you know that there were bushes right near the area where Mr. O'Keefe was found? Bushes with branches. Did you know that?
Not very close, no.
Did you see the bushes in the photographs near where Mr. O'Keefe lay?
Right where he laid, no.
How about next to him on the left? Did
Welcome,
you see
David.
those bushes?
Member of the jury. Thank you.
There was some other stuff there in the photograph, but the photographs I looked at were not of excellent quality.
Do you have any understanding or information you can share with us the angle of Mr. O'Keefe's body at the time of any impact with a motor vehicle?
I don't see any medical evidence that there was impact with the vehicle.
Do you know Mr. O'Keefe had other injuries other than just the superficial abrasions on his arm?
Yes, but no significant injuries below the neck.
How about on the head? Was there a significant injury?
Oh, yes.
When you considered excluding car collision as a source of those wounds, did you consider in your history that you've seen, or have you seen, let me strike that, have you seen in your history multiple victims of a car collision where they were hit by the same car?
Probably, but I can't recall a specific case.
Would you agree with me if a car ran into a group of people and caused a number of injuries, those injuries to different people could vary wildly from one to another?
Yes.
Even if the car was going at the same speed and ran into a group of people, those injuries could be totally dissimilar from one another, couldn't they?
Yes.
Some person, unfortunately, could be killed if the car was going fast enough and hit them the right way. Yes?
Yes.
Another person could have a less severe injury, maybe a broken bone.
Yes.
Another person in the same exact collision could have scratches.
Yes.
In fact, there are cases, I'm sure you've studied, where people have been hit by cars, thrown airborne, and had no wounds on them at all. Have you seen that?
Could you repeat that?
Are there instances that you have considered where a person is hit by an automobile, actually thrown, removed from the ground, thrown in the air, and gets up unscathed with no injury at all?
No significant injuries, correct.
So a car collision can cause wildly different injuries depending on many, many unpredictable factors. Isn't that fair to say?
Yes.
When a vehicle's involved, have you ever been involved in treating patients that received injuries from broken plastic or broken glass in a car?
Yes, many times.
And when you've seen them, have those injuries differed on a person as far as cuts and abrasions from glass or broken plastic?
Yes.
When you were considering excluding car impact or collision as a source of Mr. O'Keefe's injuries, did you consider whether or not Mr. O'Keefe could have been struck on the side of the car in a clip-type event rather than being run over?
Yes, I considered multiple scenarios.
Had you, or do you agree that injuries from a side swipe or from a clip could be much, much different than a full rear or front impact being run over?
They could be.
Did you do any study in this case when you were thinking about excluding the car collision or impact as the source of Mr. O'Keefe's abrasions about what his body posture was, how he may have hit a motor vehicle? Did you consider that?
I considered several scenarios, several different positions.
And when you considered that, what did you conclude as far as Mr. O'Keefe's body movement at the time of any potential impact?
Oh, first of all, I didn't see any medical evidence that there was an impact. There were no significant injuries from the neck down, no fractures, no bruise, no internal injuries, no lacerated organs, no collections of fluid in the lung cavities, the abdominal cavity, no significant injuries from the neck down, and so yes, I used that and tried to put that in a scenario of his various positions. What could he have been? Standing, kneeling, sitting, lying down on the ground. I did all that.
You were a police officer before you went to medical school, weren't you?
Yes.
You had arrived at scenes of many, many car collisions, hadn't you?
Yes.
What is oftentimes left behind after a car collides with an object?
Debris.
Debris field, yes? Did you look at the debris field in this case?
No.
In the cases that you went to wherever you saw car collisions, some of the debris that you would find could be broken glass or broken plastic. Isn't that fair to say?
Yes.
And when you went to those scenes, you would often find broken glass or broken plastic in a debris field near where the victim was found or laying. Isn't that fair to say?
The debris field would be usually near the collision, if there was a collision impact.
And when you were considering excluding car impact or collision in this case, did you take a look at the entire debris field to determine how close or far it was from Mr. O'Keefe's body?
I couldn't tell on the photographs.
I'm sorry, please finish.
I couldn't tell from the photographs.
And before you came to your conclusions, did you ask anybody for any more information so that you could make a fair assessment of that information?
The injuries here were so characteristic that, and they were so parallel to one another that I couldn't even imagine pieces of glass or plastic or even metal lining up to cause those injuries, lining up in a certain fashion to cause those regular striations.
Rather than imagining, did you make any effort to actually seek information so you could identify and evaluate the debris field around Mr. O'Keefe's body that morning?
I did not.
Have you ever, as a police officer looking into car collisions, ever hear of the term knocked out of one's shoes?
Not as a police officer.
Have you ever heard of that as a medical expert?
I've heard of it as a civilian, yes. Not as a medical expert.
Could I have Exhibit 74B, please? In your study, before you gave an opinion excluding an impact or a collision as the cause of Mr. O'Keefe's abrasions on his arm, were you aware of this photograph where Mr. O'Keefe's sneaker was found on the side of the road?
I am aware that that there was one shoe off, correct.
Were you aware that it was wedged right up against the curb? Were you aware of that?
I'm aware. I have been aware of that, yes.
And when you came to your conclusion that you offered that the injuries are not consistent with a impact or car collision, was this photograph part of your consideration?
No.
If you could have Exhibit 99D, please. In your study to give an ultimate opinion, where you suggest that a car collision or impact was not the source of Mr. O'Keefe's arm injuries, were you aware of this photograph of Mr. O'Keefe's hat found at the bottom of the snow in the corner of that yard?
No.
Do you see underneath that hat there was not 2 inches of snow? It looks like dirt and grass?
Yes.
When you gave the opinion that he was on 2 inches of snow, would it be important to know whether or not he fell directly on the hard ground or on snow?
It could be important. However, it could be if the ground was frozen. If it wasn't frozen, it could matter a little bit.
Exhibit 73, please. When you were reaching your conclusions, you said you considered some of the debris field. Did you see this photograph of a piece of taillight that matches the defendant's taillight of her SUV? Did you consider this piece of evidence that was found in the debris field?
Not specifically.
76A, please. Same question. Did you consider this piece of the debris field when you were coming to your conclusions that you offered us yesterday?
I considered that there would be several pieces of metal, plastic, or glass at the scene.
Did you consider this picture of plastic from the defendant's rear taillight found at that scene? Did you consider that before you gave your opinion to the jury?
No.
You can take that down, please. Would there be any significance in your study in the foundation of your opinion that a collision or impact did not cause Mr. O'Keefe's wounds on his arm? Was it important for you to determine whether or not the taillight to the defendant's Lexus was broken early that morning?
I think there needs to be more to the question.
Okay. When you were considering potential causes of injuries, did you know that the defendant's Lexus rear right taillight was broken in missing pieces?
Yes.
Was it important to time when that taillight was broken?
What do you mean by time?
You understand that Mr. O'Keefe was found on January 29th, 2022, yes?
Yes.
Early morning hours?
Yes.
When you were making your differential diagnosis, was it important for you to learn whether around that time the defendant's taillight was broken?
It was important to know. I still don't understand the question. I'm having trouble understanding the question.
It's my fault. I'll try to ask it a different way. You were considering as much facts and information as you could to give a solid opinion in front of this jury, weren't you?
Yes.
And you ultimately have offered an opinion that the wounds to Mr. O'Keefe's arm are not consistent with an impact or a collision with a vehicle, yes?
That's correct.
You know the vehicle in question in this case is the defendant's vehicle, her Lexus.
Yes.
And you learned that her right rear taillight was broken and missing pieces, yes?
Yes.
Did you want to know if there was any evidence depicting when that taillight was broken, in considering this conclusion?
Yes.
Did you know that there was video from 5:07 a.m. showing that the defendant's taillight was missing pieces?
Objection, Your Honor.
I'm going to allow that.
Not at the time, but I expected that if there were a collision, that there would be pieces of the car, involved. So it didn't really make any difference.
When you were trying to rule out a collision between Mr. O'Keefe and Ms. Reed's vehicle did not cause these injuries, did you want to seek that information about the broken taillight and date and time it?
A broken taillight in and of itself could not cause those injuries. There would have to be multiple projections from the vehicle that were lined up in certain pattern to give those parallel marks all in the same direction. So, that's why a broken taillight could not have done that.
So in your investigation, you did not want to know when that taillight was broken?
Oh, I did, but for information only.
Did you review the ring video from 5:07 a.m. at Meadows Ave?
Later on, later on in the, not initially when I had the initial records, but later on I did.
Did you have that information before or after you arrived at your opinion?
Oh, after.
So you had already arrived at your opinion, then you received new information, which was that ring video, correct?
And it confirms, yeah.
And then you received more information. Did you receive photographs from a dash cam during a wellness check showing the defendant's Lexus missing pieces of her right rear taillight at about 8:03 a.m. that morning.
Would that be? I'm not sure which video that is.
Well, it's not a video. If we could put up Exhibit 10. It actually was from a video. Did you look at this picture during your differential diagnosis?
I think I've seen that picture before. The vehicle parked. Yes.
Exhibit 11, please. Did you consider this picture in your differential diagnosis?
I didn't. I don't know that I ever saw this picture.
Seeing this picture, do you see that the right rear taillight is missing pieces?
I can't even see that. Oh, yes, I do see that. But again, these pieces would have to be lined up in a certain configuration in order to cause those wounds.
So seeing this photograph now for the first time, it doesn't in any way shape or change your opinion, does it?
No.
You had, as a police officer, when you're excluding the source, and in this case you're saying the cause of Mr. O'Keefe's scratches on his arm could not have been from a collision, do you listen to witness testimony or do you review witness statements?
Objection, Your Honor.
I'm going to allow that. Just, do you do that?
As a police officer, in investigating a car accident, is that what you're asking me?
Yes.
Did I listen? Did I take witness statements?
Yes.
Yes.
And do you value the statements as part of your analysis?
I give varying values depending on what I believe to be the veracity of the witness.
Have you listened to the statements of the defendant herself in this case regarding potential impact?
No. What do you mean?
Well, have you seen any statements made by the defendant to any media about potential impact or collision in this case?
Oh, are you referring to what you've asked me previously about? Did I hit him or something of that? What do you mean specifically?
Have you seen any of the media statements by the defendant, 2020, Nightline, docuseries? Have you seen any of these statements in your analysis of whether or not there was a impact, a collision between the defendant and her Lexus and Mr. O'Keefe? Have you seen any of those?
I did see some statements, but that was after I rendered my opinion.
And some of those statements, after you rendered your opinion, did some of those statements come from the defendant herself?
Yes.
And when you listen to those statements, did you hear any of them talk about the idea or issue of collision or impact?
Yes.
And when you listen to those statements after you formed your opinions, did in any way change the analysis of your opinion?
Absolutely not. And I'll tell you why.
Please do.
Because the defendant had undergone a very stressful event, finding her loved one in the snow. And so after a stressful event, many people suffer from what's called an acute grief reaction. It's very common. And they do things that seem to be irrational. They ramble. They act bizarrely. They make statements that are irrational, that don't make sense, and they oftentimes tend to blame themselves for whatever has happened. I've seen this many, many, many times in the emergency department.
Does this happen moments after a stressful event?
Oh, yes.
Does it happen months later when you go on 2020 or Nightline?
I've never seen that situation.
Yeah, no. Does it happen a year later when you go and speak to documentarians and be interviewed? Is that the same kind of condition you see a year and a half later?
A grief reaction can last years. It usually is very brief, but it can last years.
Now, when you looked at the clothes in this case, Mr. O'Keefe's clothes, you are aware that those clothes were swabbed for DNA traces, weren't you?
Yes, I'm aware that some of the clothes were swabbed for DNA.
Could we have Exhibit 147B, please? On the right arm, there were a number of different tears in that fabric that you looked at, weren't there?
Yes, there were a number of small round holes in that
You're
fabric.
aware, aren't you, that those holes were swabbed for traces of dog DNA?
Objection, Your Honor. Like to approach, please.
Okay, come on up.
The testimony was not that the holes were swabbed for likely dog DNA. It's that some areas of the clothing were swabbed. But exactly where was swabbed, we don't have that information. They did not swab the hole. And if they did, they did not report that. Cole, I was watching and just got kicked off your channel. Welcome back. I'm sorry. YouTube has had some issues lately, just a couple issues. We think we fixed the audio clipping issue. So hopefully that nobody's having problems with that today. If you are, let me know. That evidence was not presented in this trial. Facts not in evidence. Two swabs were used to swab the entire sleeve. I think it was a mistake by Mr. Brennan to let her explain that, because the testimony about the grief reaction was not helpful to the Commonwealth. It basically just accounted for the bizarre behavior that Karen Reed showed that morning, and said that's perfectly normal and natural. Even the guilty part, did I do it? Is it my fault? Did I, that focus. He opened the door and said, "Please explain," having no idea where she was going to go, and that one turned around and bit him in the butt. He scored some points though too. Mr. Brennan got her to admit that she would expect at the scene of a collision broken taillight pieces on the ground, which is what Commonwealth says we have. And she seems to have formed her opinion prior to viewing a lot of evidence. So a little pluses and little minuses on this one for both. I don't think this is a home run either way. Mr. Brennan has delivered a lot of snark, and I would say he's doing a very effective job questioning. Especially when she says, "I need to see the transcript," and it's before showing her the transcript. He solidifies her testimony today. What's your opinion right now? That gives him an extra point to critique her against what she said before. Very, very skilled in that area. But see, when asked if she had experience or education with accident reconstruction, she's like, "Actually, I was certified in hit and runs." Yes, she was a police officer in Massachusetts before she went into her medical career. Just a little gruntled says, "I don't agree, Ari. I think he's just trying to exhaust her into saying he's right." He's had to try to twist her words a number of times to get what he wants out of her, and she's been able to hold her own, saying, "Actually, that's not what I'm testifying to." It's a little lawyer trick to try to get one statement to be equal to another, and she's caught on most of the times and has not given him that satisfaction, which has frustrated Mr. Brennan. We hear that in his snark. Has anyone commented on the jury's reaction? The last comment I heard was that the jurors during this portion have sort of stopped taking notes. That could mean a number of things, but basically, to me, it might indicate that they, at this point, are not receiving additional information that they find valuable. That could be two ways. That could mean that they have discredited this witness in their mind, and they're just going to cross that off, or they could say that they've already got what they want from this witness, and this attack on her by Mr. Brennan is not changing that. So we won't know which one it was until they come back with the verdict. Nothing to note. These objections are taking a long time. I think very soon here, the judge would be remiss if she did not mention something to the jury to remind them that the comments by the lawyers are not evidence, and that they need to stop making those comments. Both sides have done it. Mr. Brennan has done it just most recently. so they're. This is the game that's played back and forth. Dog has 60 teeth. It's a lot of teeth to brush. Camilla, following on Twitter, I think this might be from Sue. Is this from Sue O'Connor? Updates about the jurors. Juror number 1, yawning. 2, looking down, sitting on hands. 3, writing notes. 4, looking at the Reed family. 5, looking at sidebar. 6, looking around the room. 7, scratching head. 8, leaning on hands. 9, standing. Yeah, there is one juror who likes to stand. 10 is sick. 10 is sick. Whoa, that's terrible. 11, looking down. 12, arms crossed, looking at the sidebar. 13, looking at me. 14, looking at the sidebar. 15, looking down at notebook. 16, looking at the fan. 17, looking towards the O'Keefe family. And 18, looking at the sidebar. So that's what they're doing right now. Thank you, Camilla, for passing that on. It's great to have court watchers.
Longer than any of us wanted to do while you're sitting here. So we're going to continue what we're doing, but we will give you the morning recess. So that's about a half an hour or so. Okay.
All rise for the court, please. Close your notebooks. Follow me.
So the sidebar will continue, possibly in open court. Once the jurors are out of the room. And maybe we'll address some of the new documents that have come out. The missing witness request has got a little more juice to it now to dive into. 3 missing witnesses that the Commonwealth should have called, which the defense says we request a missing witness instruction with a negative inference.
Sam, watch your step coming down. Follow me.
Jurors, exit the courtroom. Please be seated.
All right, here we go. Let's let Dr. Russell leave as we talk about something that's not necessarily...
All right, Mr. Alessi, I'll hear you.
About her so much as about the process was going on here.
Mr. Alessi, I'll hear you.
Thank you, Your Honor.
Excuse me, Mr. Brennan. I'm going to go to the podium and your carrier is there.
Mr. Brennan, can you remove? Oh, okay, it's being removed.
Mr. Alessi is going to briefly use the podium. Mr. Alessi doesn't do anything briefly. He does everything thoroughly. DSN, thank you for the super sticker. Appreciate it.
Thank you, Your Honor. Attorney Brennan, just with regard to Dr. Russell, in open court in front of the jury, used the concept of DNA in this case. He has introduced it and brought it in for the very first time in front of the jury. He has done so intentionally. He intentionally brought up DNA. Based upon that intentional mention, the defense moves strongly, vigorously for a mistrial with prejudice. A mistrial with prejudice. There has been no mention in this trial of DNA with regard to the topic with regard to what Mr. Brennan has raised. There has been none. Specifically, the prosecution had, in the first trial, had a witness, Terry Kuhn, with regard to DNA. For whatever reason, the prosecution has chosen not to bring that witness in who would testify perhaps to DNA. As a result of that strategic decision that the prosecution made, there's been no mention. I want to be very clear. The defense has been incredibly assiduous and meticulous about not mentioning DNA in any fashion, directly or indirectly. With regard to the hoodie shirt and the hole, the only thing that was adduced in direct examination was a mechanical function simply of Dr. Russell testifying that a dog tooth went in and came out and caused a certain mechanical effect on the yarn. Nothing even close to the mention of DNA. With regard to representations that Attorney Brennan has made that somehow there was a hearing that we were on notice, it is completely incorrect. Show me the hearing, show me the transcript where that has been discussed. The prosecution has also said, we're going to, or we always intended to bring on rebuttal Dr. Crosby, who would talk about the supposed absence of DNA, the alleged absence of it. The problem with that of trying to rescue the mistrial that the prosecution has caused with prejudice is that Dr. Crosby could never testify about such a topic, because I would object and object because there would be no foundation, because the prosecution strategically chose not to bring in the foundation whatsoever in this trial. The fact that they did it in another trial, or perhaps did it, is irrelevant to this trial, as Your Honor has admonished several times. What happened this is a new trial, and whatever happens in the first trial is the first trial. So in conclusion, Your Honor, because of the conduct of the prosecution, and specifically the intentional mention of DNA, the prosecution has put in the jury's mind that topic that is irremediable. That cannot be reversed. That cannot be cured. That cannot be ameliorated with a jury instruction. That cannot be dislodged. The prosecution has to suffer the consequences of its own intentional actions of bringing up that topic. Ms. Reed is entitled, under the Constitution, under the Massachusetts Declaration of Rights, to a fair trial. And what has just happened is antithetical, abhorrent to a fair trial. The only remedy is a mistrial with prejudice.
Now, Mr. Brennan.
Okay, thank you.
Gets a shot.
Mr. Brennan.
He brings up a post-it note worth of notes, because that's all he thinks it's worth.
Inquiring of Dr. Russell about the absence of dog DNA is not only proper and permissible, it's essential, and the Commonwealth is entitled on cross-examination to explore theories and facades that the defense creates if there is actual evidence that undermines or contradicts the representations that they are trying to portray to this jury. Let's be clear. The defense is on notice that there is no dog DNA in the sweater of John O'Keefe. Let's be clear. The defense is on notice that we were not going to try to disprove all of their varying theories in our case in chief, but if they were going to propose theories that we thought were unsubstantiated, we would do so in rebuttal. It is clear these witnesses are on the witness list. More so, The conversation and examination of Dr. Russell is replete in the historical record of this case. Dr. Russell herself testified on December 12, 2024, that she did consider the absence of DNA in her opinion. She disregarded it, she discounted it, she created false theories about the potential destruction of it, but she did testify this was part of her consideration for her opinions. Again, on January 7th, 2025, Dr. Russell again discussed the absence of dog DNA in John O'Keefe's sweater. Now, it may be inconvenient, it might be hurtful for the defendant's theories, for the creation they portrayed for this jury yesterday, but it is not improper, it's not unconstitutional, it's not irrelevant, it's very relevant. It is powerful evidence that the Commonwealth has to undermine this idea that the linear superficial abrasions on John O'Keefe's arm were somehow caused by a dog. They, on their case in chief, tried to create impressions about the cause of the abrasions to Mr. O'Keefe. The defense does not get to pick and choose what words the Commonwealth can or cannot use. They do not get to pick and choose what parts of Dr. Russell's opinions are important and not important. Because they chose not to emphasize, highlight, or discuss the absence of dog DNA on direct does not mean it's beyond the scope of direct examination. It means they did not want to talk about it because it was not helpful to them. There have been countless cross-examinations in this case where questions are asked beyond the scope of direct. This is not beyond it. It goes to the heart of her opinion. If I cannot cross-examine her, as proposed by the defense, about the heart of her opinion, she shouldn't give it. She shouldn't have an opinion, because you can't come in and just take the favorable factions to yourself and leave out reality. I intend on asking Dr. Russell about her opinions, about the role that the absence of DNA played. Also, I expect to ask her about her attempt to diminish or demean the DNA evidence, because it shows her inherent bias in all of her opinions, where she acts as an advocate, not as a scientist or a doctor. It is admissible evidence. We intend on using it. And when she returns to the stand, these are the very questions I'm going to ask her.
Your Honor, may I have a brief 1 minute?
Sure, go right ahead.
Thank you, Your Honor.
Case law.
Your Honor, a key misstatement of fact that Attorney Brennan just made. He said that Dr. Russell talked in prior proceedings and hearings about dog DNA. The record is abundantly clear. She only did so in response to a question from Mr. Brennan. I have the transcripts right with me. She never raised it affirmatively. She gave her opinion that these wounds were to a reasonable degree of medical certainty from a dog. Mr. Brennan on cross said, did you consider, and this is in a prior proceeding, did you consider DNA? She gave her answer. She didn't raise it. I heard it. I was there. Your Honor was there. So this impression that Mr. Brennan is trying to give, that somehow the defense brought this topic up before, is incorrect. The second point, Mr. Brennan needs to have a good faith basis to ask the question. To have a good faith basis, he has to have some admissible evidence that he's got for it. He has no admissible evidence on dog DNA with regard to the arm. He knows he doesn't. He strategically chose not to bring that evidence in this case. Now he's saying he wants to use it. That would be improper in this trial for that reason. The other 2 points quickly. Mr. Brennan alleges an absence of dog DNA with regard to these wounds in the right arm. There was no swabbing of the wounds to of the right arm of Mr. O'Keefe. That is a major, major investigative flaw in this case. That should not be befallen upon the defendant. Secondly, there are, with regard to the hoodie that was one, I believe, swab taken, and we don't know much about it, but what we do know about it is there are horrible, tremendous chain of custody and care with regard to the hoodie, conceded, virtually left on the floor of the ambulance, left on the floor of the hospital, carried around by Mr. Proctor for weeks, maybe even months, not submitted for testing for months. There are huge issues that prevent a fair determination about whether there was even proper determination of whether there was DNA or not. So in conclusion, Your Honor, the defense has never brought up DNA or alleged absence with regard to the right arm of the hoodie. It's always been the prosecution. We were meticulous and assiduous in not doing it here. The prosecution needs to live with the consequence of its action. This is remediable, and I respectfully submit warrants only one ruling respectfully, and that is this trial must be declared a mistrial with prejudice.
May I have 30 seconds?
Sure.
Judge doesn't seem too plussed by this.
The
Now he's got
defense
a
can
computer.
pound their fists and yell as loudly as they want, but they can't change truth and reality. Whatever the motivation is for wanting a mistrial can't be based on a claim that the prosecution raised DNA for the first time with Dr. Russell at the Lanigan hearing. If we actually look at facts and reality, rather than making false claims about everybody in the courtroom and everybody else who comes in here, what we'll see in the transcript, and this is the December 22nd, December 12, 2024 transcript, I direct the court to the direct examination of the attorney who just accused the government of raising it for the first time. Despite his words,
what page
we have page 83, line 21. We have page 122, line 14. We have page 124, line 14. These are the words of Attorney Alisi on direct examination. And there are more. There are more. But that is enough for the court to understand that the representations are wholly mistaken by Attorney Alisi. Wholly.
All right, thank you. We'll give everybody a half an hour. So
All right.
My prediction is we will be back and continue in half an hour. I do not foresee this ending in a mistrial right here. I've been wrong before, but I don't think don't think it ends here. But let's just put a little perspective on this. The judge agreeing to take half an hour to consider this instead of dismissing it on the surface might give this argument a little more credence. She wants to choose her words very carefully if she's going to continue this, because this is an issue. This is not a frivolous objection meant to throw the questioner off. This is something that is more nuanced than that. There's more to it. We're going to go back and I'm going to show you what happens just a brief bit ago. If you guys missed it, I know a lot of people said, they said, what happened? I missed it. Why are we talking about mistrial all of a sudden? Hang on. Okay. Wait for the window. There we go. Clean feed to there. We've got sound, I think. We're gonna replay really quickly because we've got half an hour to do this. We're gonna replay the very ending portion of. Let me see if I can find this here. The very ending portion. Where's my spinny wheel? Wait for it. It's connecting. Okay. Let's go back right here. There's no sound yet. Hang on. We're talking about the shirt. Okay, here we go. Let's start right here. And And the audio did not connect. 1 second. I wish it would automatically switch when I do this. Output to HDMI. Okay. And we're back. It jumps completely. Wait for it.
A number of small round holes in that
You're
fabric.
aware, aren't you?
Okay, she's talking about the John O'Keefe's hoodie, the sweater, the sleeve that he was wearing. She says there were a number of small round holes on it, talking about the dog bite on the arm. Mr. Brennan comes in. You're aware, aren't you?
That those holes were swabbed for traces of dog DNA.
Okay, he barely gets the question out before the objection's fired off by Alessi. The question was, you're aware that those holes were swabbed for the presence of dog DNA. We didn't have testimony, even in the original trial, that the holes were swabbed. Okay, so that is an inaccuracy there. We know that there was a swab collected at some point from somewhere on the sleeve. We don't know where.
I'd like to approach, please.
Okay, come on up.
The judge's voice, okay, come on up. I think she knows that this is a problem. I think she knows. Now we're going to fast forward just a little bit. So let me turn the sound off so you don't get a long little break here. Look right here.
Coming down. Follow me.
Jury is exited the courtroom. Please be seated.
I've never seen Mr. Alessi as fired up as we're going to see him in this little replay while the court is on break. So Dr. Russell leaves the room. This is not about her. This is all about Mr. Brennan. It's all about the question. It's all about bringing
Mr.
up
Alessi,
DNA.
I'll hear you.
If it's dismissed with prejudice, there cannot retrial. It would be
Mr.
case
Alessi,
over.
I'll hear you.
Thank you, Your Honor.
Excuse me, Mr. Brennan, I'm going to go to the podium and
Mr. Alessi says, Mr.
Mr.
Brennan,
Brennan, can
I'm
you
going to be
remove-
using the
okay.
podium, and
It's
you've got
being
your
removed.
crap all over here. Come and get it. Let me put the, oops. Let me put the replay in the corner so you guys know we're on replay right now.
Thank you, Your Honor. Attorney Brennan, just with regard to Dr. Russell, in open court in front of the jury, used the concept of DNA in this case. He has introduced it and brought it in for the very first time in front of the jury. He has done so intentionally. He intentionally brought up DNA. Based upon that intentional mention, the defense moves strongly, vigorously for a mistrial with prejudice.
Okay, so based on this, he's saying that alone, Mr. Brennan bringing up DNA and doing it now in cross-examination when no testimony has been given in this trial. The prosecution has rested their case. We have presented all the evidence we're going to present to this jury at this point. And at that point, the trial could have been over. Okay? Defense could have said no witnesses and we'd be in deliberation, right? Jury instructions, deliberation. For him to now come in and say, you're aware that we tested those holes for dog DNA, right? When there's the jury's not aware. No, they have no clue. They're like, oh, you tested it for dog DNA? What were the results? Well, the fact that Mr. Brennan is bringing it up right now in the mind of the jury, he wouldn't be bringing it up. It's like, we tested it, and you're right, Dr. Russell. You're right. Canine. That's what we got. We got dog DNA. No. Mr. Brennan would never bring this up if the facts weren't in his favor. The problem is the facts are not in evidence. And he just brought it up. And Mr. Alessi says, you can't fix this. You can't. You can't just tell the jury, never mind. You know, ladies and gentlemen of the jury, please, there were some comments made about DNA testing. for dog DNA on the sleeve. Just pretend that didn't happen. Can everyone nod your heads affirmatively? No, you can't. You can't make this go away. You can't put the poop back in the horse. You can't unsqueeze the toothpaste and get it back in. It's a done deal. And there has to be something done here. We'll see what it is.
Call from Angela.
Good morning, Angela. How are you doing?
I'm doing good. It's actually kind of dinner time, a very early dinner.
It's not my fault your clocks are off.
Because I am actually...
Just kidding.
I am actually... It is actually officially my lunch break right now. So technically, yeah. Wow, my lunch break came at the right moment.
Did you get to watch it live?
I managed to catch the... Yeah, I got to watch it live.
That's cool. What are your thoughts?
It is... Brennan is playing a dirty game. And he is well aware that he is losing this case, that jury loves Dr. Russell, and he is trying to bring evidence last minute and shift the burden. I don't know. It's mind-blowing, not to say another word, but it is mind-blowing what he is doing. Wow.
What do you think about the judge, though? Yeah, I can hear you. Do you think the judge will actually grant that? Do you think she looks at this and says, "Yeah, this is, we've spent untold millions on this case. Let's go ahead and call a mistrial here with prejudice because it was."
I mean, the only way or remedy could be that they call the DNA person that tested the DNA in the rebuttal, but then defense has to do our sub-rebuttal or whatever the name is. And after that, I mean, how many rebuttals are we going to have?
What about this? When in other cases, I'm thinking of Lori Vallow in Idaho, when there's been a mistake made, there is a punishment on the other side. The only punishment at this point that the prosecution could be given was when they get something taken off the table in the charges. What if the judge came back in and said, I'd like to have a sidebar, and said, defense, I do think that there's a problem here. I don't think it rises all the way up to mistrial with prejudice. But if we took murder 2 off the table, would you be okay with that?
There is still a problem. Jury heard this, and they did not have. Prosecutor Brennan did know that they are going to call Dr. Russell and Garrett, and he still chose not to call the DNA person in. And I have a lot of questions for whoever swabbed the DNA. We don't know where those swabs were taken. And it was one swab for the whole thing. It wasn't one swab per hole, it was one for everything. And that's a problematic alone.
Yes.
And also, those clothes were, it can also be explained, those clothes were he was in the snow. DNA can be distorted, destroyed in the snow. It can also explain the lack of evidence, lack of dog DNA, because it was in the snow.
Yeah. I think the judge saying I need half an hour when it's just the morning break, where we've almost got as long a break as we get for lunch here. It's significant. She has to craft something. She has to address this. She probably has to phone a friend, and make a decision here.
Like Albert.
She has to butt dial. She has to butt dial a friend really quickly,
yeah. Oh my God.
I didn't hear any case law argued on either side on this one, and I realized this just barely happened. They didn't have much time to research this, but I was sort of expecting, at least on the second time Mr. Alessi or Mr. Brennan got up, that they would cite some sort of case where they're like, this isn't a problem, this happens all the time, here's an example in case law. where it was ruled that it was okay, or this is a major problem. Here's the last time that this was overturned on appeal because because it was allowed to continue. So, but no case law cited.
Yeah, it is not I don't know if there is a case law, but she has to think also about herself. She has how many overturned? This is major appeal issue. If she is convicted, even of the lesser charges, I can bet money it will be overturned in record time.
Okay, if it's overturned though,
I can bet money.
Is it with prejudice?
I don't know if it will be on, but she has to think. She has a reputation of a couple bad trials that has been overturned. I don't know the details, but she also has to think of herself and her reputation. She has already been called out for being biased, and the people know that she has a few bad trials behind her, but overturned. And she has to think. If she allows this, will it come back to bite me?
It'd be interesting. I think she's near the end of her career, if I understand correctly. She's going to be done here soon.
Yeah.
Somebody asked me to replay a part of the court when Dr. Russell was walking away. I'm going to do that while you're on the phone here with me, Angela.
Can I say something? I watched yesterday. Some of it I watched this morning on my way to work, and the rest this morning. And Dr. Russell is so nice and so likable. Even if she is trying to be as neutral as possible, she comes across as someone who does not give a frick about the case. She is there to testify about what her expertise is. Also, she's a doctor. She is allowed to use elimination process in order when diagnosing something. That is allowed as a methodology in scientific community. That is allowed. She used that. His expert, Doctor end of quote, Crosby, he has very questionable methodology, and she pointed that out. Also, one last thing, and then I promise I'm going to end the call so someone else can call.
One.
Yes, regarding the someone helped her to edit the whatever they edited
report,
from Alessa's office. Yes, it's called cleanup. As I am doing right now, I'm writing a paper right now, and we are doing a cleanup. Which means that some stuff, you have to have this red thread whatever report you write, whatever paper you write, you have to have this red thread in order for someone to follow the report step by step. And I guess that her report needed some cleanup, so that can be there, this red thread that people can follow it step by step. I don't think she did anything unethical by asking someone to clean up the report. It was just something that is used, that's called edit, and it's nothing added, it's nothing removed, it's just, put stuff where they belong.
I agree. Thank you very much, Angela. Appreciate your comments today. Good talking to you. I would, as you go here, I just want to say that I think that if this was a problem, the judge would have addressed it. If this was a sequestration order issue by Mr. Alessi saying, "Hey, ask for she would have addressed it already." So, Angela, thank you very much. Appreciate the call. Enjoy your lunch.
Thank you.
We'll see you.
Thank you. Bye-bye.
Bye. All right, we have. I was going to show this replay one more time. This is right as Dr. Russell was leaving the courtroom, and right before this argument. And you guys said, take a look at the court reporter. She's the one standing here. So if you guys want to take a look here, I'm going to play it about 50% speed, maybe a little bit faster so it's smoother. She turns. Dr. Russell now walks across the screen. Court reporter looks at Dr. Russell, does once up and down, little sigh, looks up, shakes her head, rolls her eyes, and turns away. Uh-oh. Uh-oh. Yeah, she needs to not do that. In this case, the jury's not there. It's not going to be a problem one way or the other. Don't think defense saw it. They were all back here doing this. So nobody saw the exchange. They were focused on what was going on next. There's a couple times she's had some reactions in court, but shaking, I don't think it's warranted to shake your head at that witness, particularly.
It's Mattis.
Mattis, I was beginning to think your phone got confiscated by the International Calling Police or something. How are you doing, my friend?
No. I'm doing reasonably okay. I still got some work to do today, so I'm gonna be at the work laptop while I have you on the other screen.
Awesome.
I wanted to briefly call so you can maybe get a better idea of what specific rule Alessi is talking about.
Okay.
So if you let's use your search engine of choice and enter mass.gov and then Massachusetts Guide to Evidence. There should be some Massachusetts government page that can let you just download the file.
Okay. I'm going to use DuckDuckGo. Does that work? No, just kidding.
Yeah, I also use DuckDuckGo.
I'm not using Bing. Go ahead. I'm on Massachusetts Guide to Evidence, which
okay. So there is, when you have this document, you want to go to, so I'm on the page that I have. It says it's Article 6, Witnesses, Section 611. You might want to show the screen, on the screen.
Let me put it up here
on
just
the stream, because I just want to see if we're on the same page.
Yeah, we are, because we've been on this one, but hang
so
on
the section is, I'm just going to read out loud here. Section 611, Mode and Order of Examining Witnesses and Presenting Evidence.
Okay,
the relevant part is B. Scope of cross-examination. Yeah, this, you have this, and then when you go, you can actually, 6 and then 11. And then I think you have to download this, or you can scroll down, and then we go to B.
Okay, we're going to part B.
And your
scope of cross-examination.
Maybe.
Does that work?
Yeah. So scope of cross-examination. 1, in general, this is the key. A witness is subject to cross-examination on any matter relevant to any issue in the case, including credibility and matters not elicited during direct examination. And then this is the relevant sentence. There must be a reasonable and good faith basis for questions asked on cross-examination. The trial judge may restrict the scope of cross-examination in the exercise of judicial discretion. So this is not really like a specifically maybe like a case where you have specific case law on point, but this is why Alessi is objecting. It's just this is the broadest possible general. You have to have a good faith basis to ask the question rule. You can't ask questions in bad faith. You can't ask Dr. Russell, say, Dr. Russell, your opinion about dog bites is nice and well, but did you know we actually have HD Ring camera footage of Karen Reed's vehicle knocking over John O'Keefe? Well, obviously you can't ask that. You don't have that. You can't just ask questions that insinuate that evidence exists that helps you. Why would you even bring that up? It's kind of like if you consider the judge's pre-trial ruling on, say, Colin Albert, which I think is his name, you couldn't say randomly ask a witness, well, isn't it true that didn't you know that people were hiding Colin Albert's identity, and didn't you know that he had bloody knuckles, and didn't you know that he loved fighting, and then he was peacocking to fight people that he didn't like, and that he was an agitator? You can't just randomly ask this question. You can't. You have to. One of the things is you have to have some good faith basis to think the person can give you like a meaningful answer to your question. You can't. So there are things in evidence, or maybe not in evidence. So you can't have like a theory and then ask every witness about that theory.
What about what Alley Cat says here?
Anyone about Chloe?
What about what Alley Cat says here, that Hank presented the question with a false premise?
Yeah,
he knows they didn't swab the holes.
Yeah, so he asked, well, didn't you know that we specifically tested the holes for dog DNA? You can't ask if you have to have a good faith basis to think that the holes were in fact for dog DNA. Like you need to establish that you think that's actually true. And Alessi's point as well, that's not true. We have like records of what was done here, what DNA testing was done. There was very poor, there was like the absolute nominal minimum of DNA testing something. There was like one swab of whatever, like a non-specific area. I don't even remember it because part two, there was no witness. No one even said anything about it. And now you're bringing it up and you're insinuating like a very specific thing. That's basically the basis for saying Brennan did not have a good faith basis to randomly throw in, hey, didn't you know we have proof of no dog DNA?
Yeah. Interesting. Let's see what the judge comes up with after this half hour. I do, based on all previous rulings, I do think this case is going forward, but her reasoning is going to be very important here as well, because if she makes a decision based on flawed reasoning, that can be, that will be in the appeal. So, interesting.
And I think for the appeal, might be kind of a hard thing to win, because I think like whether someone has a good faith basis, that might be reviewed for abuse of discretion. But maybe the record is like, maybe the appellate judges will say, well, the record is actually very clear that there's no good faith basis to insinuate the level of testing for dog DNA that would convince a reasonably critical defense lawyer turned special prosecutor. I don't know how that works.
Yeah.
I barely got through Florida cases. So.
Mattis, I have to ask you, have you reconsidered my offer to, have you come over and stay in the Airbnb while you take your law exam here in the U.S.?
Yeah, I just got to get into Harvard. Apparently, they're not doing so many student visas now. But
you can stay here in North Carolina and then just do a day trip up to Virginia. You don't have to go through law school.
That's a good idea.
You can take the test.
Yeah, very practical. Mm-hmm. I'll think about it.
Do it on a weekend, on a whim. I think you'd do fine.
Yeah.
Awesome.
Yeah, I forgot this weekend.
Awesome. Matt, it's great to hear your voice again. Thanks for digging in deep on this one. I love your technical analysis, and I think you really should be a U.S. lawyer. But welcome, and get some work done today. Thank you very much.
Yeah, I will. I also want to shorten the wait time, so hope
that helps.
We get at least a good explanation for this ruling.
Yeah.
And have a great day, everyone.
Thank you very much. You too.
Bye.
Bye. I'm just checking the timer here. It looks like we were two hours on the dot onto our recording. So we've been out for 25 minutes and 8 seconds right now. 25 minutes and 8 seconds. So break is about another 5 minutes, roughly, when the judge comes back, if she comes back on time. Let's see. We have three choices now. Taillight, done it. Dog, done it. And the bushes now. Yeah, the bushes was an interesting one. I don't remember the bush questions from the first trial or the hearing. Was that new or not sure? Do you think Hank gets a bonus for a conviction? I don't think so, because he's a government employee. Most government employees don't get bonuses. Sometimes in the federal government, there are some incentives and bonuses, particularly related to finding solutions that cut down on waste, fraud, and abuse, or that perform a required task or objective much more efficiently than it currently is. There are suggestions. I know when I worked in the federal government as a contractor, I made one such suggestion and made a little tool that cut down on a ton of overtime hours required. People calling people off shift and making them work, which they didn't like, and cut down on a ton of that. And my boss, because I was a contractor, I could not put in for that, but my boss did put in for that, and she did win. And then she retired. So I don't know. I don't know if how much she got for that, but it's pretty funny. Contractors can't receive any kickbacks at all, but the civilians can. All right. Just got here. Can anyone let me know what's upset baguette? We are in a break right now while the judge is considering the arguments of Mr. Alessi. Oh, it looks like we're coming back to court now as well. Mr. Alessi, regarding a request, a vehement request, a vigorous request for mistrial with prejudice, because Mr. Brennan brought up DNA on this cross-examination of Dr. Russell, something that he has not brought into the case thus far. He probably didn't because, A, it has Proctor all over it. The DNA issue, the clothes in question that were swabbed, they were in Proctor's trunk for weeks, if not months. The swabbing was done in an unconventional way, which is not very specific. It was recorded pretty poorly. So you've got all these issues about the chain of custody of the DNA swabbing itself. He did not bring it up. We didn't have any DNA analysis. And there's also a slight issue. The only DNA they did find was of a pig on his pants. Pig DNA. And some people are thinking, why pig? Pig ears? Like a dog chew toy? Could that mean that there was a dog? You know, it doesn't help the Commonwealth what they did find. They did not find dog DNA on the test. But anyway, so we'll see. We're pork rinds at the bar. Yeah, so that's where we are right now. She's taken a half-hour break, which is a long break. And before that, we had, the jurors had, hang on, right now, I am two and a half hours into our recording today. And the jurors have had almost an hour break from this. I'd say about a 47, I don't know, 53-minute break because of this from when they were excused. Alyssa did pitch a good fit, though. I enjoyed it. He pounded the table. He raised his voice. The only thing he said incorrect, I think he tripped over his words right at the end, was he says, "This is remediable," which to my understanding means this can be fixed. But then he said, but the only fix would be to do this mistrial with prejudice. And prejudice means that the Commonwealth would not be allowed to bring the case again. If it's a mistrial without prejudice, that would be what we had at the end of we had just a mistrial. But a mistrial without prejudice would be, yes, we have to start over. This jury, for whatever reason, cannot continue in this deliberation. We're going to stop it. We're going to call a new jury, and we're going to start again at the beginning. And a lot of you are like, no, please, no. Right, we're not going to do a trial 3 here. There's a point where if you can't get a conviction, you might want to stop trying, because this is tax dollars at work here. And I realize that everyone wants to see justice done, and when you don't have a resolution in a case, it feels like somebody, got away with something, possibly. So the suspect's either the canine, the shrubbery, or swine. Commonwealth there has tried cases 3 and 4 times. I'd be curious to know if those cases
you are unmuted
were as expensive as this one. Aperture would need another $400K. We'd have to buy another Lexus. Quarters back. Judge has all her books. Looks like we're continuing. Here's her ruling.
All right, so the motion for mistrial is denied. Your rights are saved. And Mr. Brennan, you can continue with this line of questioning.
Whoa.
Nor I did not address sidebar, the other issue that's under court's consideration regarding Dr. Walsh's opinion.
Yeah. I don't see it without a foundation. So if you can build a foundation, I'll consider it. I do not believe that foundation has been laid yet.
I would expect that foundation would need to be substantial, specifically whether or not it was relied upon by the witness.
Yes.
Could you do that outside the presence of the jury so that I don't ask the questions in front of the jury?
Oh. Yes, but not right now. They're on their way. All right. Do you have an...
I'll work around it.
Okay.
I'll work around it.
Your Honor, I would object to it being done outside the jury. That it should be done like I've had to do with several witnesses in front of the jury.
Okay. If that's what the defense wants. Are you sure, Mr. Alessi?
Oh, wait, I'm sorry. Let me confer with my...
The judge says, think this one through.
I am going to, yes, Your Honor, we are going to agree
Oh, dear.
to outside. Thank you, Your Honor.
Okay.
He says, on second thought, voir dire sounds great.
Thank you.
I'll be done
Because
very quickly.
things can go badly very quickly.
Are the lunches
That was sort of
here?
funny. Are the lunches here? Are we going to take lunch right now? What's
Are
in the
they
lunch?
still over there?
We might go straight to lunch.
How long they are?
Did you start yet, or can you turn?
If they're downstairs on their way up, I don't want to stop them.
I could do it in 2 questions.
Yeah, please.
Oh. Excuse me?
They're still over this way.
Great. Okay, they're going to stay.
Your Honor, if it might help, obviously, with subject whatever Your Honor does, based upon if Mr. Brennan only has 2 questions, I may have 30 minutes that I could, most 35, to finish up whatever redirect that I have, if that affects Your Honor's scheduling for the jury.
I just didn't want to stop them if they were on their way. They haven't yet gone downstairs.
No, I don't think they made it downstairs.
All right, we'll do this now. Okay?
Dr. Russell, during your review of the case, did the defense offer you the report of John C. Walsh, MD, Deputy Medical Examiner?
I didn't hear the whole
I'm sorry.
question.
During your review, the defense provided you materials. Did they provide you the report of John C. Walsh, MD, Deputy Medical Examiner?
I don't recall.
May I approach?
Yes. Can we turn the fan off over here, Tony, please? Or, thank you.
Tony?
Dr. Russell, did you ever review or receive that document from the defense?
She says no here. It's a dead issue. She says yes.
Oh, yes.
And regarding Dr. Walsh's opinion, did you consider that when you formed your ultimate basis that the wounds on Mr. O'Keefe's arm were consistent with the dog bite?
Yes.
Did you disregard it or agree with it?
I disregard. I disagree with his assessment.
Thank you.
That's
I'd like to inquire.
Your Honor, I would object. This is the same exact issue I had to deal with because the witnesses disregarded it, and I was not allowed to pursue questioning. So I do not believe, under the standards that's been set in this trial, that a proper foundation has been set.
What do you say about that, Mr. Brennan? How is this any different?
Pardon me?
I'm talking to Mr. Brennan. How is this different with this witness's analysis?
Because they specifically opened the door when they had her vouch for her own credibility, extolling her uniqueness and ability to determine that these were dog bite wounds. And so when they opened their own door to vouch for their own credibility and suggested that they're the only person or a limited person in the entire country that can do this, they should be confronted that they are not alone. There are other experts. And so this isn't affirmatively bringing it in. This is when the defense continually opens the door and creates these issues.
What do you say, Mr. Alessi?
Thank you, Your Honor. My response is this. I'll give 2 quick examples. Dr. Welcher, Trooper Ball, Dr. Squirty Bello. They talked and opened the door under Mr. Brennan's theory of opening the door widely. They even had, as part of their direct examination, documents in Dr. Welcher's slide that mentioned Dr. Squirty Bello. You'll recall that slide. They even had material from the CARS team with a file named Trooper Ball.
I'm not letting it in.
Thank you.
All right, I'm not letting it in under that, Mr. Brennan. So you can mark the report if you want, but for that reason, I'm not. For the reasons stated by the Commonwealth, I'm not letting it in.
I don't need to mark it.
Okay. All right. Thank you, Hunter.
That was Thank you, Hunter. Bring the jury. For the reasons stated by the defense is what she meant, not the reasons stated by the Commonwealth. She says, I have to be fair in this one. We didn't allow them to go into Proctor's report. We didn't allow them to go into Dr. Skodorsky's. I can't remember her name. The other guy. And you're not going into this one with her. So skip it. We're getting very, very dangerously close to lunchtime as well.
An objection. Where are we? Is it in evidence now?
It's not yet. It will be.
Okay.
Could you guys just say it in evidence?
The DNA. It's not, right?
It is not.
Okay.
Is there a question that's going to go on?
Yes, it's open. I denied the motion and allowed the line of inquiry.
Judge doubled down and said fair game on DNA. Big win for the Commonwealth here. I think Mr. Alessi should have pointed out, or maybe he will on cross, that the question, are you aware that we swabbed the holes? That is not testimony. That is not it. Judge Bev talks to Hunter, says, I'm ready for lunch. Where do you want to go? Probably just down the street to the bar. Yeah, me too. I don't know what she's saying. I'm just guessing. Yeah, big win for the Commonwealth on getting the DNA question in. No mistrial granted. Rights are preserved, which means you can appeal on this if you wish, if there's a conviction. But not only that, are we not going to call it a mistrial? We're going to allow this line of questioning to continue. So when we resume with the jury here, Dr. Russell will be asked that same question again. Because why not? Because it was allowed. Let's go back and get extra mileage here. Let's see if he words it differently. If he goes again and says, were you aware that the holes were swabbed? Please pan up. Please pan up. There we go. The holes were swabbed for DNA, or if he just says the shirt. Welcome, jurors. Please come in, have a seat.
Back in session, you may be seated.
Jurors, I appreciate your patience. All right, Mr. Brennan.
Thank you.
Probably allows them to do that. They might even get to say like a dog treat. Possible it came from dog treat.
Good afternoon, Dr. Russell.
Good afternoon.
Dr. Russell, we were talking about your differential diagnosis and your opinion that Mr. O'Keefe's abrasions on his arm were not consistent with impact or collision with a car. I was asking you specifically about some of the things you may or may not have reviewed before you formed your opinion. You looked on direct examination at a photograph in Dr. Welcher's presentation, and it had a photograph of a person who had been hit and died as a result of a collision. Do you remember that photograph you looked at?
The photograph of which one specifically?
There was a gentleman lying on the ground. His face was redacted, and there was.
Oh, that one. Yes.
You remember that one?
Yes.
And when you discussed that, what was the reason? What was your point in discussing that?
I was answering questions.
Do you know what the point was? What you were trying to deduce or?
No,
suggest?
I was just answering questions.
Okay. You have stated before that one of the reasons you do not believe that the injuries were the result of a collision or impact with a car is because there were no lower body injury breaks. Do you remember that?
That's one of the reasons, yes.
you would agree that a side swipe or a clipping collision is different than a front or a back immediate impact, like being run over. There's a difference, right?
In general, yes.
When you talk about the absence of lower body brakes, do you have any studies about the frequency or the likelihood of lower body brakes in a clipping impact as opposed to being directly run over?
No.
When you looked at that photograph that was shown to you on direct examination, did you look at the actual injuries that were listed for that gentleman and see that there were no lower body brakes?
I looked at all the injuries, yes.
And did you recognize in that photograph and slide that there were no lower body brakes?
Yes, I did. There were major internal injuries, however.
When you considered the information in this case, did you have an opportunity beyond that photograph to look at Dr. Welcher's videos about impacting a vehicle driving backwards? Did you watch those videos?
I saw an image. I saw an image.
Did you see a video when Dr. Welcher put blue paint on his arm and showed the height and the location when it touched Alexis? Did you see that?
Objection, Your Honor.
I'm going to allow that.
Yes, I saw that image.
Did you consider what's called the text stream data? Do you know what text stream data is?
What?
Text stream, the black box that shows the operation of a car, how fast, how slow, acceleration. Did you look at any of that information before you formed your opinion?
I looked at it, but I honestly did not understand it.
Did you ask anybody to help you interpret that data before you drew an opinion that the injuries were not consistent with the collision?
Well, first of all, my opinion came long before that report ever came out. So the answer to that is no.
When you have an opinion, if there's new evidence that is contradictory or different or maybe undermines your theory, do you have an open mind to reconsider your theory?
Yes, I do.
Did you want to understand that information about the text stream data and the information that was available regarding this allegation? Did you want to understand that before you came back and offered the same opinion you had before that information was available?
I didn't understand it, and I didn't know that if any of the attorneys understood it, actually.
Did you know anything about Mr. O'Keefe's cell phone data when you were drawing these conclusions about when his last movements were? Did you learn anything about that?
No.
Did you know about any type of DNA testing on the defendant's rear taillight area?
Yes.
And did you know about any hair found on the car?
Yes.
Did you consider those things when you excluded the collision or impact as the cause of those wounds?
Well, I considered that. However, he had, my understanding is he had been in and out of that car, on many occasions, and so therefore there would be reason for either skin cells or DNA or possibly other, hair, fabric to be on that car.
So when you consider testing your conclusions, do you look at it as an advocate or do you look at it as a scientist or a doctor and try to value how little or how strong that evidence is?
I'm looking at it as a neutral party, a doctor, a scientist.
So you're not looking at it as an advocate to try to discourage the strength or weakness of evidence?
Excuse me?
You're not looking at it as an advocate? You're looking at it as an independent professional?
I'm not an advocate at all.
When you talked about John O'Keefe's sweatshirt, can we put that up, Ms. Gilman, please? You identified or discussed some of the tears to the right sleeve of Mr. O'Keefe's sweatshirt, didn't you?
We discussed one puncture to the right sleeve, yes.
Having an interest in dogs and dog bites, certainly you're aware in your experience when a dog bites, it creates quite a bit of saliva, doesn't it?
It can.
It can actually, a dog can froth, is what they call it. Excessive saliva when it's in the moment.
Some dogs, yes.
And some dogs, they can shed hair. especially when they're interacting with other objects, don't they?
They could.
Hair is considered trace evidence, isn't it?
Yes.
And saliva contains important items sometimes like DNA, correct?
Yes.
And that's considered oftentimes very important trace evidence.
Yes.
And Dr. Russell, are you aware that one of the criminologists took swabs of holes on the left sleeve of the sweatshirt?
Objection, Your Honor.
No, are you aware of that?
Yes.
You've heard of UC Davis, haven't you?
Yes. And in reference to that previous question, however, the swabbing was done many weeks after the death, and there were images of clothing on the emergency room floor. So, yes, I am aware that there was some swabs taken at some point.
Is that gratuitous answer part of your advocacy or a part of your medical objective opinion?
Objection sustained.
And so you're aware that these holes were swabbed to send a sample to UC Davis, aren't you?
Yes.
UC Davis, do you understand they specialize in dog DNA?
Animal DNA, I believe.
And you also know, in giving it before you gave your opinion, that when they were tested, there was no dog DNA found in any of the samples. You knew that, right?
Yes.
In fact, what was found was pig DNA.
That's correct.
And there's no identification where the pig DNA came from, is there?
I don't think so.
So when you saw the information, after you claimed there is a dog with John O'Keefe, when you saw the information that they were swabs done of those holes and the results were no dog DNA, did you consider that before giving your ultimate opinion?
Yes.
And in fact, you've tried to discount the significance of that evidence in the past, haven't you?
Yes.
In fact, you have made claims about that evidence candidly with no foundation whatsoever, haven't you?
I explained why there could be no dog DNA found.
You were claiming that it was inconsequential because a number of speculative reasons. Didn't you?
Objection, Your Honor.
So the objection sustained. You can ask it differently.
When you were discussing the absence of dog DNA on Mr. O'Keefe's sweatshirt in the past, were you trying to make suggestions that perhaps the samples could have been tarnished or compromised in some way?
That's one possibility, yes.
As a independent, objective expert, should you deal in possibilities, or is it a better practice, best practice, to deal with objective criteria in the form of actual opinions to a reasonable degree of certainty?
It would be best to go through a process to determine, or at least come up with a list of reasons as to why dog DNA was not found. There are a number of reasons. You know, if you have a test in medicine, you expect it to be positive, and it's not positive. You go through a process of trying to figure out why the case is that way. There are many reasons why there could have been no dog DNA found.
When you first gave your opinion, you didn't even know about that DNA testing, did you?
Not initially, correct.
But then once learning about it, you were not willing to reconsider and change your opinion about the source of these scratches. You maintained the same opinion you had before, correct?
I reconsidered, however, my opinion did not change.
What you suggested is there's possibilities, is the word you would use, possibilities why there were errors with the DNA, yes?
Yes.
You can't tell us anything based in fact. Wait,
no.
I'm sorry. You can't tell us anything based in fact to support the claim that something was wrong with the testing of this DNA, can you?
Not in fact, but again, you have to go through a process. If you expect a certain diagnosis or a certain finding on a lab test and it doesn't materialized, and you wonder why, and you want to know, was the test done correctly, was the specimen handled correctly, et cetera, et cetera. There's a process.
And in that process, you found no evidence whatsoever, none, zero, to support any claim of compromise of that DNA process, did you?
Well, ideally, the swabbing should have happened immediately or very soon after the incident. So there was a delay in processing or swabbing to begin with. And then, of course, I don't know about the transportation or the chain of custody.
You were a medical examiner, weren't you?
Yes.
When you were a medical examiner, when you examined a person or their body, you did everything you thought was reasonably necessary based on the information you had, correct?
Yes.
Did you know at the time Dr. Scorbello did the autopsy, there was no claim whatsoever that a dog caused these wounds?
Yes.
Did you know that claim didn't come about until over a year later?
No.
And did you know that in response to that claim, that's why this was done at a later time? Did you know that?
Still, for a complete investigation, this should have been considered by investigators early on.
Even where there was absolutely no claim or evidence whatsoever that a dog caused these wounds?
Well, again, a complete investigation.
You can't tell us one step that went wrong with that DNA process, can you?
The process, no.
In fact, you have admittedly very little experience with DNA.
I have little personal experience with DNA.
And yet, although you're not an advocate, you are willing to advocate trying to undermine the strength of that evidence, aren't you?
No, I am a scientist, and I'm trying to understand why it could have been negative.
As a scientist and providing a medical opinion, do you try to exclude in your differential diagnosis all other reasonable causes of a wound?
Generally, yes.
And did you do that in this case?
Yes.
Now, when a dog bites a sweater, would you expect that it would leave DNA?
Yes.
When a dog bites a sweater, you would not expect it would leave little fragments of taillight shards in clothes, would you?
Correct.
And so in this case, when you were developing your theory and differential diagnosis and excluding causes, did you consider that when Mr. O'Keefe's clothes were scraped, his pants and his shirts and his sweatshirt, what was discovered were minute, small fragments of broken taillight that came from the defendant's motor vehicle?
Objection, Your Honor.
I'm going to allow that.
Did you consider that?
I didn't know that at the time.
Could we have 201D, please? Dr. Russell, this is a photograph.
Can we approach on this, please?
Okay.
It has to do with the wording of that question. If we go to the last question and listen to that one again, let's see what he said here. Okay, let's go back and listen in. Ready? This is the replay.
Did you consider that when Mr. O'Keefe's clothes were scraped, his pants and his shirts and his sweatshirt, what was discovered were minute, small fragments of broken taillight that came from the defendant's motor vehicle?
Objection, Your Honor.
I'm going to allow that.
Did you consider that?
I didn't know that at the time.
Could we have 201D, please?
That came from the defendant's motor vehicle.
Dr. Russell, this is a photograph.
And then Mr. Alessi says, Your Honor, can we approach? Came from the defendant's motor vehicle. I think he has to say that matched, or found to have matched the material in the taillight. Maybe his did you consider question is so irritating, it's just hint he's about to testify and not the witness. Right. He's allowed to lead, though. He's on cross. That's where he shines here. Just a reminder not to use all caps in chat, please. Thank you.
Dr. Russell, were you aware that very small fragments,
it's allowed,
shards of plastic that match the broken taillight of the defendant's Lexus were found when criminologists scraped Mr. O'Keefe's shirt and sweatshirt?
Yes, I became aware of that.
Did you become aware of that before or after you came to your opinion and conclusion that Mr. O'Keefe's arm abrasions were not caused by a collision or an impact?
After.
And when you learned that, did you get a chance to see this photograph to see how small many of those pieces were?
Yes.
And would you agree that broken plastic, like broken glass, can tear fabric?
Yes.
Would you agree that broken plastic, like broken glass, can rub up against a person's skin, and if enough friction is caused, it can cause abrasions?
Yes.
Would you agree that if fragments like this were randomly in the sweatshirt, that it could cause cuts or abrasions to Mr. O'Keefe's arm?
I don't believe that fragments that are randomly in the sweatshirt or clothing would cause the parallel abrasions, the pattern of the parallel abrasions that we saw in the arm.
Do you know how Mr. O'Keefe fell to the ground and what movements his body and arm made as he fell to the ground?
Not definitely.
You don't know?
How? No.
Do you know how much distance or little distance he moved when he was on the ground?
Yes, approximately, I think it was 20 feet. I initially heard 60, but around 20 feet, I believe.
You think, do you know where his body was found on the side of the road?
Yes.
Do you know if his body, before it rested, moved or slid on the ground?
Yes, it did.
And it's your opinion that fragments like this could not have caused the superficial abrasions to John O'Keefe's arm?
You know, in reference to that last question, actually, that I don't know that there was a collision, but I know that it's alleged that there was movement of the body after the collision.
I wasn't asking about the collision, I was asking about his body. Are you telling us to a reasonable degree of medical certainty that these type of fragments that were found in his clothes could not have caused the superficial abrasions on John O'Keefe's right arm?
This is live.
They can cause superficial abrasions, but not in that pattern that we saw on the arm.
I'm going to ask you the question again. Are you saying to a reasonable degree of medical certainty that these fragments did not cause the superficial abrasions to John O'Keefe's right arm?
Correct.
It's just like correct. Yep.
I have no further questions.
You end with the defense statement?
Thank you, Your Honor.
Okay.
Why did I think it was Mr. Jackson or Alessi that was questioned? Oh, it is Alessi. Mr. Jackson is helping here. Mr. Jackson questioned her the first time. Mr. Alessi's doing this in this trial. Everyone's getting excited about this. Mr. Jackson's buttoned up his suit. Ready for the show. It's time for lunch, so please hurry. About half an hour.
Thank you, Honor.
What kind of tablet is that? Massive one.
May I, Your Honor?
Yes.
Thank you. Your Honor, I would like to have published what is in evidence is 201A, and then I'm going to proceed after that with 201E.
Okay.
Dr. Russell, I have up this exhibit, and with regard to the questions of Attorney Brennan that he just asked about these alleged shards, can you tell the size of them from this depiction?
I don't even see any shards in that depiction.
Can you read that slide and see the handwriting that is there?
Yeah, it looks like clear app plastic collected from 7/18/18. There's another date over to the left side, and then it says AMV 6/29/23.
Right. And if Mr. Wolk, you could go back. Can you determine at all from this whether the shards are microscopic or not?
I cannot see any shards.
All right, let's go to 201E. With regard to this depiction, do you recognize what is in this depiction?
It looks like irregular, red-colored pieces of debris.
Thank you. And do you recognize the ruler above those pieces?
I'm not sure if this is the same ruler as in the previous image, but there does appear to be a ruler.
If we could go back to the previous slide, does that at all assist you in determining whether or not it's the same ruler?
Not exactly, but there are similarities.
So let's go back to, flip back to the next slide. Does the, what is up in black help you reach any conclusion about whether those pieces are microscopic in size or not?
Well, so those are, again, I'd like to go back, but I think those might be 16th or 32nd of an inch if we're using the same edge of the ruler. Those pieces that are depicted are not microscopic because we can see them with our eyes, but they're extremely small.
All right, so they're extremely small. You've asked, you want to go look back at the ruler. Does that further assist you in your analysis as to the size of these pieces?
16. So those looks like they're maybe a 16th of an inch or less.
Okay, so let's go back, Mr. Wolk, one more time. So these pieces are a 16th of an inch or less, correct?
Yes, if we're using the same ruler.
Right. So with regard to, and if we could, Mr. Wolk, now go to Exhibit 1.
It's the arm.
Attorney Brennan asked you several questions with regard to whether those 16th of an inch or less pieces could cause these types of abrasions. You have addressed this issue, but I would like you to answer whether those pieces, a 16th inch or less, could cause, now knowing the size, whether they could cause these abrasions, including with regard to this pattern.
I don't believe so.
And with regard to that answer, how do you come to that conclusion? What is your thought process?
Okay, again, there are multiple parallel abrasions. So these pieces would need to be lined up in a certain configuration to cause those abrasions, and they'd have to be oriented in nearly the same direction, because many of these groupings of wounds, and if I may use the pointer, are oriented in this direction a little bit, well, anatomically a little inferior to superior, ever so slightly this way. So they're oriented in the same way. So not only would they, those abrasions are rather large for those tiny pieces of plastic or glass, but they'd have to be oriented in a certain way to cause those wounds.
As an emergency department physician, as a forensic pathologist, what is the likelihood, if any, that those shards could cause those wounds?
You have to ask it differently, Mr. Wilson.
Dr. Russell, please state your evaluation and conclusion and the basis for it as to whether those shards of glass, or excuse me, shards of plastic, 1/16 of an inch and less, can cause those abrasions on and wounds on the right arm of Mr. O'Keefe.
I do not believe that they could have caused those wounds.
Is that a close call for you to come to that conclusion?
Not at all.
You were asked several questions by, please keep that depiction up, Mr. Wolf. You were asked numerous questions by Attorney Brennan where he wanted you to go section by section by section and evaluate each. He grouped these, I think, 5 or 6. Do you recall that questioning?
Yes.
Is that a scientifically proper way to evaluate this wound to determine whether or not it is from a dog? Is that a proper methodology to look at each individual section only?
No.
How, at a scale, is it improper to evaluate them that way under your methodology?
Sustained.
Dr. Russell, what is the proper way to evaluate the wounds on the right arm to determine whether or not they're caused from a dog?
To look at patterns, because individual wounds can vary, but the pattern is what is significant.
And on your direct examination, did you go through this method that you just described, a pattern and pattern recognition? Did you go through that in some detail and discuss that?
Yes.
Now, you were asked questions by Attorney Brennan, and in his questions, it was asserted that you don't have a standard, a published standard. Do you recall that questioning?
I'm going to allow it.
Do you recall the question asking whether you had a standard to reference for your methodology? You recall that questioning?
In reference to dog bite wounds, yes.
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 And with regard to the question and assertion in the question with regard to a methodology, you referenced studies, and as part of your answer, do you recall that discussion with Mr. Brennan?
Yes.
Do those, and are those studies peer-reviewed?
Yes.
And give the name, please, again, that we had gone over on direct, but give the name of the lead authors of each of those studies.
Yes. So one of them was by Dr. D. Munich, and the other one was Dr. Pollock. And by peer review, that means that it's the article was reviewed by other physicians in those respective specialties of the authors.
I'm sorry to interrupt you, Dr. Russell.
I'm sorry. Finished? The specialties of the authors, yes.
If we could take that down for a moment. Your Honor, may I approach, please?
Okay.
If I could have, Your Honor, from Madam Court Reporter, exhibits marked for identification P, 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 and Q, Q, Q. Right. And I'll start with P, 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 if I could, please. Thank you, Madam Court Reporter. May I present PPP to it? Thank you, Your Honor. Dr. Russell, you have before you PPP. Is that the study with the lead author, Dr. DeMunich?
Yes.
Do you recall Attorney Brennan in his questioning asserting that you had no basis and there was no support for your methodology of pattern recognition? Do you recall that discussion?
Objection.
Sustained in that form.
Do you recall questioning on the cross-examination by Attorney Brennan as to your basis for a methodology in terms of pattern recognition with regard to dog wounds? Do you recall that?
Yes.
Can you please take a look at exhibit PPP for identification and identify whether there's any section in that study that talks about and documents the methodology that you used in that study?
Yes. So this is an article that was published in the International Journal of Legal Medicine, and it is entitled Forensic Approach of Fatal Dog Attacks, a Case Report and a Literature Review. And so it's several pages long, talks about a specific case, and then on page 298, there are some significant passages that I would like to read, actually. So it says here, dogs have some very specific dental and maxillofacial features. They have 42 teeth, 20 in the upper jaw, 22 in the lower. Usually the mandibular dental arch is narrower and shorter than the maxilla, and that means upper, lower and upper. Maxillar is the upper. Maxilla, and the shape of the dental arches varies among the different breeds. There are natural gaps between the teeth that are attenuated or accentuated depending on the breed. The canine masseter pterygoid complex is short and strong, and its insertion on the mandible provides powerful mechanical advantage. So that's talking about the muscles, how powerful they are. And then it goes on to measure the forces.
If you could find the location, if there's any in there with regard to pattern. Is there any discussion about attributes and patterns in that study?
This next paragraph. The above features attribute to the characteristics of dog bites. The maxillary teeth distal to the mandibular teeth allow the so-called scissor bite in which the dog can lock onto his prey. The tremendous force of the bite muscle complex can develop, allows the dog to twist and tear, and cause great damage. The injuries caused involve a combination of biting, crushing, tearing that results in characteristic patterns of punctures, lacerations, avulsions of the skin and soft tissue. Forensic pathologists noted the multiple torn wounds with adjacent puncture wounds, the so-called hole and tear combination. That's in this case. The puncture wound around hole is made by the canine tooth of either the upper or lower jaw on one side that serves as an anchorage, while the other teeth cut into the flesh, causing stretching lacerations in the process of biting, shaking, and tearing. This should be considered pathognomonic for dog bites, especially when accompanied by tissue defects and claw marks, the latter being narrow, superficial, linear abrasions arranged parallel to one another, 4 or 5 in number, and usually found in the vicinity of the bite. This pattern allows differential diagnosis with bites of other animals, which are not accompanied by pulling and shaking, nor by the usage of prominent canine, and with stab wounds caused by sharp instruments.
Does that study support or not support in the literature a pattern recognition methodology?
That's sustained.
What do you conclude from the language you just read in that study with regard to methodology of discerning dog bite wounds?
That pattern recognition is very important.
Now what I would like, if I could approach Your Honor.
Okay.
Sure.
Mr. Brennan's like, can I have a copy of that report?
If I could return this to Madam Court Reporter and please request Exhibit QQQ for identification. Thank you, Madam Court Reporter. May I hand it to the witness?
Yes.
Thank you, Your Honor. I've now handed you what is marked for identification as Exhibit QQQ. I would ask, please, that you, is that the Pollock study that you referenced in your direct and in your cross-examination?
Yes.
Could you please, as you did with the Munich study, can you please articulate the relevant, just the relevant sections with regard to your reliance upon that study?
Yes. So this is an article from the Institute of Forensic Medicine at the University of Vienna.
Is that a peer-reviewed study?
Yes.
Please continue.
Excuse me?
Please continue.
Okay. The title of the article is Fatal Dog Bite Injuries. And there's a summary. It says the dog's front teeth. So let me preface this. This was talking about a deceased child. And they describe the features. It says the dog's front teeth left marks of individual circular or scratch-like abrasions, as well as slit-like skin severances. Slit-like skin severances of the skin, arranged in curved lines. The pattern of the skin lesions largely corresponded to the anatomy of the dog's set of teeth. No tissue defects could be detected.
And is there any other section of that study that references pattern and pattern recognition methodology? Any other words, any other section? And if so, could you please read them?
Yes. So on page 491, there's a section called the Morphology of Dog Bite Injuries.
What does morphology mean?
It means the shape. And so it goes on to say the anatomy of a dog's teeth is the key to interpreting injury findings. The particularly long, cone-shaped, pointed canine teeth often create sharp-edged wound slits that can be mistaken for stab wounds. The bite mark on the skin is ideally a complete and congruent imprint of the front dental arch. Sometimes only the protruding canine teeth are imprinted. If the shorter incisors leave an impression, smaller skin lesions, parentheses, round pressure marks or streaky glide marks, can be found between the impact points of the canines. In practice, it is hardly expected that all 6 incisors will act uniformly.
I'm sorry, I didn't hear that sentence. Could you repeat that?
In practice, it is hardly expected that all 6 incisors of a jaw will act uniformly.
Is that sentence relevant at all to what you've referenced as an incomplete bite?
Yes.
How is it relevant?
Because if not all the teeth impact, then you get a partial bite. You know, you get irregular appearances. There's another sentence that's important here. A gap in the injury pattern can have several causes. Oblique biting, so what that means is not dead center on, but off to the side a little bit. Oblique biting. Curvature of the body surface, which we could have in this case around the arm, the edges of the arm.
Mr. Wu, could you please put Exhibit 1 back on the case? And Dr. Russell, would be helpful as you're discussing these items if you could determine whether or not what's discussed in that study is at all depicted in this exhibit.
Okay. So we discussed oblique biting, which is off at an angle. Curvature of the body surface. So here we have a body surface that's actually quite irregular. There's curvature down here. There's definitely curvature around the elbow, and so there's curvature around the bones. So curvature of the body surface can change the appearance of the wounds. Interposition of textiles, so that would be clothing.
Is there an example of interposition of textiles in this case?
I don't think so.
Well, was the decedent in this case wearing any? Is textiles mean clothing?
Yes, and I thought you meant in this article. But yes, there was textiles in this case. Mr. O'Keefe was wearing that hoodie sweatshirt or sweater shirt. So interposition of textiles. And then it goes on to mention some other things which I don't think apply in this case, such as different tooth lengths, tooth loss, abnormal teeth.
And is there any other aspects of that study that are relevant to your analysis and methodology with regard to evaluating the wounds in Exhibit 1?
You know, a lot of this article is relevant, and I don't know if you want to keep. I want to keep on reading.
Keep reading it, but if there is a section, because then I'm going to have a few more questions once you're done identifying the most relevant sections of the article.
Yeah, this. And then there's one section that said.
Thank you.
Oh, yes, thank you. Then it does mention that in some victims, parallel scratch marks originating from clawed paws are found accompanying the injuries.
And is there any other section that you believe supports your evaluation of the wounds on Exhibit 1?
No, I think that's it.
All right, so thank you, Your Honor. May I approach?
Yes.
Thank you, Dr. Russell. Madam Court Reporter. So do those studies, the Demunic and the Pollock that you just referenced, do they support the methodology of pattern recognition that you applied in evaluating Exhibit 1?
Absolutely.
And do they directly or indirectly support that methodology?
Directly.
And is that medical literature peer-reviewed support or not for your pattern recognition methodology?
Yes. So as to the form, Mr. Alessi.
You can't bolster the witness.
Do those studies, each of them, those peer-reviewed studies, support your pattern recognition methodology that you applied with regard to Exhibit 1?
Yes.
You limited it to the methodology, and that's good. You can't support her opinion.
Did those studies look solely at individual wounds, or did those studies' methodology look at the overall pattern to evaluate and discuss wounds from dogs?
Objection. Ask it differently.
How did those studies evaluate wounds with respect to individual wounds and overall wounds? How did the study evaluate those?
They described some individual wounds. There were numerous wounds. Described some individuals, but they looked at the overall pattern to make recommendations.
Was the overall pattern in those studies important or unimportant in the analyses and conclusions that those authors reached?
Important.
Now let's switch topics. Attorney Brennan asked you about various considerations you made with regard to differential diagnosis. Do you recall those?
Yes.
Let's just start with your differential diagnosis methodology. You describe whether or not you took into consideration additional information that was presented to you in determining whether your initial hypothesis was correct or not. Describe just generally that process and whether or not you took new information and retested your hypotheses. Describe that process that you undertook just generally.
So in general, when a physician is presented with a set of circumstances or wounds or symptoms or whatever, they come up with a possible diagnosis, but have to consider other diagnoses as well. That's what a good physician does. They consider what they think is the most likely, and then they go through a process of eliminating the or including and the other possibilities. Would you like to give an example, like chest pain or?
Well, I'd like to give you an example of what you used here in this case as the application of that.
Well, okay, so I'm just describing the overall process, because if you came to a diagnosis and narrowed in on it and never considered any other information, sometimes your diagnosis is going to be wrong, and so you have to allow for other information. And so I did that in this case. I examined the circumstances, examined the wounds photographically, and came up with my impression, but I also considered other possibilities. What else could cause those scratches or those abrasions?
And did you honestly and scientifically consider those other possibilities as you continue to review the information, old and new information in this matter?
Yes.
And did that process allow you to avoid confirmation bias?
Yeah. Yes.
So in terms of that process, now let's go through some of the items that Attorney Brennan discussed with you. He asked you several questions, one of which, did you evaluate news clips and audio clips? You remember that questioning?
I remember a question about some news clips.
And did you recall your discussion with Attorney Brennan about acute grief reaction? You remember that discussion?
Yes.
Now, in terms of acute grief reaction, you talked about it, and do you recall discussing that sometimes people who have a traumatic event, that acute grief reaction occurs? You recall that discussion with Attorney Brennan?
Yes.
Now, do you recall also mentioning that sometimes these patients engage in self-blame?
Yes.
And my question, among others, is when they go to self-blame, from your experience as emergency room physician, seeing patients with this, as you discussed with Mr. Brennan, are there instances when patients blame themselves for something when they're not to blame?
Sustained.
Can you discuss what you meant by self-blame in acute grief reaction?
Sustained.
Your Honor, may we approach?
Okay.
Yeah, I think that second one should be allowed in because Mr. Brennan opened the door. He asked an open-ended question which gave that answer about the grief reaction, acute grief reaction. And I think that's fair game. That's new. That's not something that that was covered in direct. And I think he should be allowed to ask some questions to explain that a little bit. We'll see if this is allowed. I thought that might be out of scope if she's there for dog bite evidence. Well, it might be out of scope for dog bite evidence, but she's an expert in the medical field, and she has a lot of experience with people who are injured and are, working in a trauma center, working in an ER, things like that. Years and years and years of experience, almost as much as I've been alive. And so I think she probably can speak to that. And because the prosecution brought it up on cross, the scope for redirect is the scope of cross. Well, they brought it up on cross, so I would think that redirect would be allowed to go in on that. See if this can be a quick decision. I think it might end up with us going to lunch. She did bring it up. I called it as a mistake by Mr. Brennan when it happened. When she said, "Can I expound on that?" And he said, "Go ahead." He gave her the go ahead, and she brought up this acute grief reaction, how she's seen that, and she pontificated for some time, giving a fairly lengthy statement. That this was in response to Mr. Brennan's questions about Karen making comments to the nature of, did I hit him, or I hit him, or something like that, and acting unreasonably and everything else. And so I think he definitely opened the door here. I'm not sure why. The first question I can see why that was kept out, but the second one I'm not sure why the judge excluded that. I think she should overturn her own decision on that and allow the question. Grave concern, added vocabulary. Dr. Russell has lived more in her life than many people do in their lifetimes. Impressive. You might not agree with everything she's saying, but you've got to admit she's got a lot of experience in many different fields. The no dog DNA evidence seems to be a reason for a guilty verdict, but then the no DNA on the broken taillight is ignored by the same people. No DNA is a problem, I think, for both sides. The first trial we fully covered would be Darrell Brooks. Why aren't the doctors being asked about the vomit found on John? I don't think that's come in this trial. I don't think they've mentioned that. No dog hair is worse than no dog DNA. If it was cat, I'd be with you on that one. No cat hair means that the cat was not anywhere near you. But if they just passed you across the street, you'll have cat hair on your sweater for sure. Brooks was the first trial? Yes. The first trial we live streamed and covered. Yep. Now I watched Depth v. Heard and some of a couple others around that time, but that's the first full trial we covered. No DNA. Wait, did they wash the clothing though? The problem with the clothing was it was collected. First it was cut off John O'Keefe's body, as is standard when they have an emergency response and you know, an unresponsive patient taken the ambulance so they can assess the entire injuries to him. Cut off his body, thrown on the floor of the ambulance, taken with him and thrown on a chair or on the floor in the hospital, and then collected from the hospital. We believe that it stayed with Mr. Proctor, with Trooper Proctor, in his vehicle or in the trunk of his vehicle for a period of time, because the next time we have chain of custody notes about it, it's when it's taken to the lab many weeks later. And at the lab, they did a couple tests. They did some scrapings of all the clothes and dumped the contents out of the bag that it was in, and that's where they got the taillight things. And they did a couple swabs, which included both items. So not a swab of the shirt, or not a swab of the hole, or a swab of the neck, or anything else. But that's where the clothing comes from. So it's not the most sound evidence as far as chain of custody and investigatory procedure. All right, have they went to lunch yet? No, but we might. I told you this one might end up with us going to lunch, and it's 12:50, so might have to wait till after lunch to see how this one's decided. Had to go chase down a victim's clothes that the hospital threw away. Skelly May. I made security go fish it out of the trash dumpster. It was in a bag, so no harm, no foul, but they threw it away. Just cleaning up, tidying the place up, you know. Can't have trash littered around in the hospital. His underwear and socks weren't in evidence. Okay. Lunchtime here. Let's see. Nope, it's continuing. Let's see if this is allowed. Judge is swaying, not happy. I think she allowed it.
May I have a moment, Your Honor?
Yes.
Thank you.
Nope, she didn't. He has a moment because he's moving on to a next topic.
Dr. Russell, do you recall questioning by Attorney Brennan with regard to some alleged clip with regard to a motor vehicle, the Lexus and the pedestrian in this case? Do you recall that discussion?
Yes.
And have you reviewed and Attorney Brennan asked you about the slide presentation that what Dr. Welcher did with regard to this supposed accident reconstruction? You remember those questions?
Yes.
Mr. Woke, if you could please publish the slide from Dr. Welcher's presentation with the arm out in the glass in the back. Not that one, the one in this case of the Lexus and Dr. Welcher dressed up as Mr. O'Keefe and with the clothing in the back, but with his
juror just knocked over their Stanley mug.
That would be toward the back of that slide presentation, probably around 130-ish, 120.
Sounds
That's
distinctly
it.
like
Yes.
a vacuum.
And what slide number is that? 109. So, Dr. Russell, can you see what is depicted on that slide?
Yes.
Is that impact that is depicted on this slide, is that a clip or is that a direct impact to the arm?
I believe that that's a rather direct impact.
Okay, so this is a direct impact. And now, From your experience, and you were asked about this on cross-examination, a direct impact to the arm, assume, as was discussed, a motor vehicle, 6,000-pound Lexus going 24 miles an hour in reverse with a direct impact on the arm. From your experience as an emergency medicine physician, what type of injuries would you expect to this arm?
So I would expect at least significant bruising, at least. But I would also expect fracture, possible dislocation of portions of the arm.
What portions of the arm would you expect fractures and dislocations?
Well, from this image, if it impacted that section of the arm, and let me use my pointer, right here, a very good possibility that there would be a radius and ulnar fracture of the forearm or an elbow fracture.
Could you please stand up and with your Honor's permission, show where the radius and where the ulnar bones are of the arm? The lights on, please. Thank you. You can keep the lights on.
So the radius and ulnar are the two long bones in the forearm right underneath the skin. And then they join with the humerus bone here in the upper arm at the elbow. And those, of course, these bones are they're susceptible to fracture with a significant impact. And also the elbow would be susceptible to fracture.
How about the hand?
The hand could be injured. It depends on where the hand was in relation. And also, if there was a fall, there are other mechanisms that could contribute to a fracture from the actual fall onto the ground. So there could be a wrist fracture, digital fractures. It depends on the circumstances.
Thank you. And do you, you can be seated. Thank you very much, Dr. Russell. From a direct impact to the arm, as you said, is depicted here. What is the likelihood of there being any fracture to any bone?
Objection. Sustained in that form.
Do you have an opinion, based upon a reasonable degree of medical certainty, as to whether there would be any fracture to any bone?
I believe that there's a very high likelihood that there would either be a significant bruise or a laceration or a fracture of the bones.
Now let's go to, as I understand it, you have reviewed the autopsy report of Mr. O'Keefe?
Yes.
And you've reviewed the file, the medical records files, correct?
Yes.
Is there any indication at all of significant bruising to the right arm of Mr. O'Keefe?
No.
With regard to the lower extremities, from what is depicted here, meaning this impact, did you evaluate the autopsy and the medical records to see what evaluation was done of the lower extremities?
Yes, a very extensive evaluation of lower extremities was done.
What very extensive evaluation was done, and by whom?
By Dr. Scortibello, and it was both an external and an internal examination of the lower extremities.
Let's start with the internal examination by Dr. Scortibello. Could you please describe what type of internal examination she performed?
Well, she opened up the legs.
Sustained.
May we approach her? Or lunch?
All right, jurors, I'm going to send you out for lunch. Okay.
May we approach for lunch?
Yes. Come on up.
Judge says, come on up. The objection going to Dr. Scortibello's analysis, I believe, didn't this witness already say that she discounted the finding of Dr. Scortibello's? That she disregarded it? So now it might be difficult for her to talk about it. I don't know. It's an expert talking about another expert, and it's in her field. She did not describe the ME. No, that was with Walsh. Okay, everyone goes up for a sidebar. We're going to be going to lunch here in just a minute. The jurors already have. Karen goes up this time. Alan Jackson stays back. Guards the computers. Mr. Wolk. Oh. Karen checks in with family and friends. Just briefly. Apparently, the parking meter needs to be fed, so they're going to take care of that really quickly. I don't know. That's what I gathered out of the conversation. The time shows expired on the meter. Please put in more quarters. EJ's writing a memoir. See what happens here. See if this is allowed. A little surprised by the last ruling that it wasn't allowed, and now we've got another objection in a new line of questioning. We'll see if that's going to be granted here. Someone's racing by my house. Can you bring up the beginning of today's testimony when Brennan asked Dr. Russell if she has memory problems? She gasped. Yeah, I'll pull that up. Let's see. See if I can find it here. That was before the break. It's a long time ago. Man, we've been going for a while today. It was right at the beginning of Brennan, right? We'll try to find it here as soon as they come back from this. Jackson did go up to join. This is taking some time. If I was a juror, I'd want to compare the holes on John O'Keefe's sweater with the marks on his arm. Can they take the sweater out of the display they have it in? The other jewels, if you remember, I really had a problem with the shirt being displayed the way it was. For that reason, it's very difficult to see or analyze the holes in the sweater when it's under pressed plexiglass. That's new. I've never seen clothing admitted like that before. The display thing is crazy. What's the display thing? Oh, the plexiglass. They didn't have the clothing behind plexiglass in the first trial. You're correct. They changed it for part 2. We do have our thumbnail up for after after the break, and we also have a portal set up to move you over. It was crumbled also. It was poorly laid out. I mean, if they're going to do it, if they could lay it out a little bit neater, that would have been better. Of course, it's very damaged. Do you use a sound card on your computer setup? Mark, I do not. My setup is more like this. I use a Rodecaster Pro for my audio. All my videos run through a SDI 8-port Blackmagic design switcher. I'm going to keep them. They're back from court. I have to go back. Sorry. I don't use a computer to stream. I stream through the Blackmagic switcher.
Chrissy, does that help?
Brennan grabs his phone, says, I'm out of here. Going to lunch.
All right.
All right. We don't get the ruling. We'll have to wait and see when we come back what they're allowed to go into. But I use a lot of cables and buttons. Cable-wise, I think I'm in the 70 to 80 range of cables that connect everything. So we've got multiple computers. So a MacBook Air, an iMac, a MacBook Pro over here that you can't see, a Mac Studio over here, and then 3 Apple TVs, and then a lot of Blackmagic design, a couple of recorders, some NAS storage, Stream Deck that runs everything, Sony camera, and Rode mics. So, got any questions about them? I'm happy to answer. I'm glad to help out any way I can. All right, Apple all day. I bought into the Apple Apple ecosystem, and it is not cheap to get out. It's not cheap. So, I'm stuck. This camera is a Blackmagic Design Micro G2 4K, and then this is a Sony A6600. They're about the same cost, the two cameras. But all right, let's see. Anything else? We are going live over on the new stream. There's a portal that will take you there. I will say that we have not been let down. I told you it was going to be spicy this morning, and it has been. We've had the most vigorous call for a mistrial today was denied. If you missed that, that is well worth a rewatch. Also, we've had some very heated, spirited, direct and cross-examination of Dr. Russell, which continues after the lunch break. I do expect her to be off the stands before the end of the day. Probably get to Lucky before we leave. Lucky will probably be done for today. He's a witness that doesn't need a great deal of time on the stand. Amy Hanover, welcome to the gallery. Welcome. You're here. We probably should have told you before you joined that it's actually a one-way door and you can never leave. You're here now. You're one of us. Welcome. Thank you. All right. Yes, the winner on is not Greeners on the other one. It's not Greeners. It's somebody else. It's going to be great. All right. With that, it's lunchtime. I anticipate we're going to be coming back at 1:45. If anything happens sooner than that, we'll be back with that. You won't miss a minute of court. But we're going to take a quick break and go grab yourself a bite to eat. Stretch the legs. Do a little cardio maybe. A little yoga if you need it. Clear your head or take an Excedrin, depending on as the case may be. So, after lunch, we're going to continue day 26, part 2 of round 2 of the Karen Reed trial. And Dr. Russell is still on the stand. I think we've got some more. Some more questions. Some of the things that Mr. Alessi is going to right now, I'm positive Mr. Brennan is going to want to ask some questions, some follow up on, maybe some clarification. Might have even opened the door to something. We'll see how that happens. But tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better. And please stay safe till we go live again at 1:45 or sooner if court comes back sooner with the afternoon session. Please join us over there. If you have not already, please click the subscribe button. Join 65,090 of your friends. It's wonderful. It's free. And the best part about it is once you click subscribe, you can click the notify button. You'll be notified every time we go live if YouTube works properly. So that's great. All right. Have a good one. We'll see you after lunch. Be good to each other. Bye-bye.
in front of the Walmart.